Yes.
Lordship, I beg to mention item number 34 with consent of the other side, Your Lordship. Let the matter be taken up after 2 weeks, Your Lordship.
Vikas Jain, no? What is your name?
No, ma'am. I'm A. Mishra on behalf of Mr. S.
Learned
Deuri.
Counsel Mr. A. Mishra. On behalf of
Deuri.
Learned Counsel Mr.
S. Deuri.
S. Deuri, with the consent of the other side, has prayed for adjournment. List the matter after 2 weeks.
In the meantime, interim may be extended.
Interim order shall remain in force till the next date of listing.
Much obliged.
May I please, Your Lordship?
Yes.
I beg to, with the consent of the petitioner, I beg to mention item number 17. Kindly adjourn the matter for 2 weeks.
Learned Counsel Miss, your name?
I'm on behalf of P. Bora. My name is S. Bhumik.
S. Bhumik, on behalf of Learned Counsel Miss P. Bora.
P. Bora.
Representing respondent number 1, with the consent of the other side, has prayed for adjournment. This is the matter after 1 week.
2 weeks.
After 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 16 with the consent of the other side, Lordship. Kindly pass over the matter for the day, Lordship. I'm Miss A.
Learned
Begum.
Counsel Miss
Miss A. Begum.
A. Begum, on behalf of Learned Counsel Mr.
My name is there, Lordship. A. Begum.
16. No.
Yes, Lordship. S.N. Tamuli.
On behalf of Learned Counsel Mr. S.N. Tamuli, with the consent of the other side, has made a request for Passover
For the day, Lordship.
for the day.
Lordship, kindly fix a date, Lordship.
List the matter on dated and legal. 19 March 19.
Obliged.
Please, Lordship. I beg to adjourn the item number 23 of daily course list, Your Lord.
Learned Counsel Mr.
I'm appearing on behalf of Mr. Raj Chhetri, Mohit Pandey. I'm appearing on behalf of Mr. Raj Chhetri.
Yes. Your name?
Mohit Pandey.
M. Pandey, on behalf of Learned Counsel Mr. R. Chetri, with the consent of the other side.
I'm the petitioner.
Okay. With the consent, Nalake has prayed for adjournment. Learned Counsel Mr.
Arul Sutia.
Adel Sutia is present for the petitioner. List the matter. When do you want?
2 weeks up to.
After 2
After
weeks.
2 weeks, Your Lord. Highly obliged.
May I please, Your Lordship? Lordship, item number 11 and 12, adjourn for the day, Lordship. With consent of other side.
Learned Counsel Miss
On behalf of M. Islam, Miss A. Khatun.
A.
Khatun.
Khatun, on behalf of Learned Counsel Mr. M. Islam, with the consent of the other side, has prayed for adjournment.
After 2
This
weeks.
the matter after 2 weeks.
May I please, my lord, I beg to mention item number 37. I have informed the other side. What has happened is that, my lord, in this civil revision petition, the suit has been compromised, and on compromise, the suit has been disposed of with a decree. I have a copy of the order which I have obtained from the online portal. Therefore, this CRP has become infructuous, my lord. It may be disposed of as infructuous.
And for the respond number 4.
Dearest House. Let me see the copy. Learned Counsel Mr. N. Chaudhary is present for the petitioner and has submitted that both the parties have arrived at a settlement.
My lord, the suit is also disposed of on compromise.
Arrived at a
This order
settlement,
would.
and the original title suit being TS number 3 of 2024 has been disposed of on compromise by order dated 15/11/2025. Full stop. Not a certified copy, no?
Not a certified, from the online portal itself.
A copy downloaded from the online portal has been submitted. Full stop. This copy will form a part of the record. Learned Counsel Miss
M. Kakuti for
M.
respond number
Kakuti is
4.
present on behalf of respondent number 4 and has considered to the submission
Yes, sir.
of the Learned Counsel for the petitioner and has also added that this suit has been, the original title suit number 3 of 2004 has been disposed of on compromise.
Yes, Your Lord.
Full stop. The downloaded copy is marked as X, which is submitted by both the sides that this revision petition has become infructuous and this may be disposed of. On the submission of both the sides, this revision petition is dismissed as the petition has become infructuous.
Disposed of.
Disposed of.
Disposed of, dismissed of regard nala, disposed of liquidity, dismissed nilly or disposed of liquidity. Exhibit X এটা লিখা আছে A লিখি দিন। This agreement has
The
already been
compromise
passed.
agreement was made exhibit X in the suit.
A লিখি দিয়া ইয়াত। ৰেকৰ্ড চেকৰ্ড আছে নেকি? Okay.
Applies to us.
Next, with your lordship, I would like to mention item number 28. This case arising out of a maintenance case in 158W25 in Borpeta Court. Now petitioner has been withheld the case.
Lordship, actually what has happened is the parties had entered into a deed of settlement between themselves, by virtue of which all the pending suits which were pending against each other, they have decided they will withdraw. Now, there was a domestic violence act, which was a case which was filed by the petitioner that has been withdrawn. Now, the pending is the TSM FC number 158 of 25, which was for restitution. There is a stay operating. Lordship may dispose of the entire matter. এখন দি দিবচোন sir.
Learned counsel Mr.
P. Talukdar.
P. Talukdar is present for the petitioner and learned counsel Mr.
M. Das.
M. Das is present for the respondent. Full stop. নাম কিটা নালাগে লিখিবলে. It is submitted by the by both the sides that several cases were pending between both the parties and both the parties have arrived at a settlement and they have mutually settled several cases which have been disposed of on compromise.
Lordship.
The only case pending is which one?
There are two cases pending. The present case, Lordship, the transfer petition 40 of 25 before this honorable court.
The
against-
only list pending before the petitioner is the present case. TRP within bracket civil number 40 of 2025.
and TSM FC 158 of 25, which is pending before the Principal Judge Family Court Borpeta.
Oh, only case, no, the two cases are only pending, only list pending now. Two cases are only pending, the present are and title suit number.
Title suit M within bracket M FC number 158 of 2025.
So now what we are planning to do?
Lordship, once this case, because there is a stay operating in this transfer petition, once the stay is vacated, the parties will appear before the learned family court and then close the matter.
It is submitted that as an order of stay of the TSFC number 158 of 2025 has been passed by this court on 14/7/2025. The Principal Judge Family Court is unable to dispose of the aforementioned TSM FC number 158 of 2025. Despite the settlement arrived between both the parties, full stop. Therefore, the petitioner has prayed to withdraw this petition. After considering the submissions at the bar and after perusal of the after scrutinizing the deed of, you are submitting this before this
Lordship.
court, scrutinizing the deed of memorandum of understanding executed by between the petitioner and the
Respondent.
respondent, comma, this case is dismissed or disposed of.
This will be disposed of.
Disposed of on withdrawal.
On withdrawal. Lordship, the interim order.
The deed of memorandum of understanding is marked as X
X.
and will form a part of this order as well as a part of this record. Will form a part of this order and the record.
Lordship will vacate the interim order.
Oh, yes, yes. The interim order dated 14/7/2025 stands vacated.
Deeply obliged, Lordship.
Also, she has returned to a matrimonial home with
Yes,
a minor child.
she has returned.
That is good. You can take a copy of this order.
Lordship, deeply obliged.
Maybe Your Lordship.
Yes, yes.
I make mention item number 3.
Just a moment.
The filing matter may be fixed on 11 March.
Have you taken consent?
I am the petitioner.
Oh, okay. Transfer petition.
I-
Item number 3.
Item number 3.
You are praying for adjournment.
Oh, yes, yes, also.
Learned Counsel, Mr.
Yes, no.
S. New has prayed for adjournment. List the matter after 3 weeks.
11 March. Date.
List the matter on 11 March.
March of bliss.
Item number 1.
May please, Your Lordship. একেলগে কৰি দিওঁ।
I'll first submit on the Mogdam to Kullo. Just.
Yes.
Both the matter may be together, my lord. Item number 1 and from the hearing, item number 8. Actually,
Let
item
them-
number 1 also may become as a bail hearing.
Item number 1 and item number 8.
Mogdam only filed.
Okay, Mogdam Ali, okay.
Well, I was arrested on, I surrendered before the concerned trial court on 1/7/2025.
Mm.
So till today, I am in 1 month, 1 year, 1 month and 7 days in custody. Now, all the witnesses, key witnesses have been examined.
Mm.
Yesterday, it was fixed for the investigating officer.
Mm.
We all went to do the cross-examination, but the investigating officer did not turn up citing election duty. Now, election will be over in May, and this personal liberty of this persons will be curtailed. Now, so far petitioner is concerned, my lord, his children are having their exam. I have 3 children, and mother had just a few days back, I'm told that mother had a minor stroke or something like that. That is the family side, those problems are there. Now, so far the prosecution witnesses are concerned, I have annexed all the prosecution witnesses. And if your lordship goes through the evidence of the prosecution witnesses, I'm not saying that your lordship will discuss the merit of the case, but this is a case where the chances of conviction is absolutely bleak. Now, so far the petitioner is a concern. He was a doctor of the army, and I have annexed all his awards and gallantries that he have received during his service career. Now, so far the disease is concerned, my lord. Disease, I'll not say anything bad about her, but so far the disease is concerned, she was an advocate at the Boypeta bar, and she had 16 criminal cases against her. I'm not saying that just because someone has 16 criminal cases, in spite of she being an advocate, that someone has a right to eliminate her. I will never say that. But we have been named only on suspicion, madam. Now, if your lordship looks into the charge sheet and the allegations made in the charge sheet and what was the prosecution case, they initially tried to show that we have hired contract killers to eliminate this disease. Now, when the charge sheet was submitted, where on the evidence of the star witness there, which is PW7, who is the sister of the deceased, they both of them went to a doctor in Borpeta for checkup, and after they came out from the doctor chamber in front of the house of the doctor at around, it was a winter time, around in the evening. Initially the PW7 said that she was dragged out from the car and killed outside the car by stabbing, and the basic allegation was that I was holding the neck, and the other two, one had snapped and the other had eloped with the all 3 have fled in the bike. Now, so far the person who has stabbed, he is on bail. The person who was part of the conspiracy and who took them away from the place of occurrence, he is also on bail. So far, allegation that was made against me, they said that I was holding the neck of the deceased. But During cross-examination and all, it turns out that they had a civil dispute. What was the civil dispute? Civil dispute was that this doctor, after his retirement from the army, he has a checkered army career, he purchased a plot of land, and this deceased, she had took around 1 crore 30 lakhs and odd money from all the retired benefits money there, she has taken, and that's why they want to say that this may be the motive of killing him. But later on, when during the postmortem and all, and even the eyewitness, nobody has, because there are independent witnesses also there. They have said that we have not seen anybody being taken out from the place of occurrence. Now, so far, the independent witness who are near that place of occurrence, they have not named any one of us. Now, so far, the PW7, who is the her statement, if your lordship looks, is full of contradiction and embellishment. But your lordship will not discuss the merit of this case now because that will prejudice us during the trial. But for your lordship's satisfaction, your lordship can look into it, the statement of PW7. The PW1 is the informant who is the brother of the deceased. And his statement also, your lordship may look into it. He also has kidnapping cases in Chiliguri and all criminal antecedents and all. He is not even an eyewitness. So these are the two witnesses only who has tried to implicate us, and they said that since because we have a civil case, the IO, so far the civil case is concerned, he did not investigate anything. He did not take out any material to show that this may be a case of exaggeration or false implication. Those things are there. That will take the minute. Now the stage is set for IO. We cannot influence the witness because all the witnesses have been examined. And here your lordship will find that there is no element of criminal conspiracy, that section 120B alia is also not there. So we cannot influence the witnesses. At this stage, my respectful submission is that any further custodial detention is required during the trial or not. My respectful submission is that at this stage, my lord, further custodial detention may not be necessary so far to trial is concerned, because we also need to prepare our defense. Because I, being a doctor, at the time of the death, my lord, I was working in Borpeta Medical College and Hospital as a doctor. I also have to give evidence that I was on that particular day, I was on duty, I was not present at the place of occurrence. If your lordship looks into the evidence of the electronic evidence, the investigating authority has seized all the mobile phones and the CDR of the persons who were arraigned as an accused in the case. Now, so far, the CDR and the mobile, when we did the cross-examination, there was nothing to show from the CDR and the mobile forensic that we were present at the place of occurrence. So, considering all these facts, my lord, although, my lord, earlier your lordship has rejected it, we went to the Honorable Supreme Court against the order of your lordship. But the Honorable Supreme Court said, let the key witnesses be examined. After that, you move the bill again. That's why we are before your lordship. And we have, it's not that the prosecution did not have a time yesterday. Also, they had a time to produce the IO. So we took the date today, so that at least they should not say that we are not given an opportunity to examine the investigating officer and all. I respectfully submit that considering all these factors, my lord, your lordship will kindly consider the bail. Now, this is the month of Ramjan also. I am told that mother is not keeping well also. And he has 3 small sisters. And looking to compare the antecedents, someone just saying in the name that I was holding the neck of the deceased. But if your lordship looks into the postmortem report and all, there is no evidence of anyone, any injury to the neck or she has died by a single stab injury. And during cross-examination, we have also examined the person who had seized, who was seizure witness to the clothes. These clothes of the deceased were also not sent for forensic examination. I don't say that for the lapse of the investigating officer, your lordship will give us the benefit. I will never say that. But at least they must give certain element of to ensure that we are in detention till the trial is concluded now. And immediately, I don't think, my lord, that the trial is going to conclude in the next 6 months, because after that IO also, it will take around 4 or 5 days. Then after that, my lord, statement defense. Then we have to give defense witness also, because I, being a government servant, I will have to collect those documents from the hospital and to show that I was on duty on that particular date. I have to give my evidence of my wife also to show that I was with her at my matrimonial home on that particular time. And the investigating officer tried to pinpoint us because the
You
basic.
were at home or you were in the clinic?
No, after I came from the hospital, I, along with my wife and children, was in my in-laws' house. And that's why the police seized the mobile and the CDR from the, if your lordship looks into the statement of the electronic evidence, the last witnesses, your lordship will see that the CDR and all, they tried to show that if they could have shown from the tower dumping, they have collected the tower dumping location and also, they did not find us any of this mobile active in that particular area, my lord. See, my lord, your lordship knows only that under Article 21, everyone is entitled to a fair trial. If I am kept just for the sake of keeping in custody for last more than 1 year, 1 month and 7 days, how I will establish my innocence in the case? Only hurdle till now was that the observation of the Honorable Supreme Court that, and that also why it has occurred, my lord, because there was an observation that key witnesses have to be examined. Now, there can be an argument from the both sides that even the investigating officer is also a key witness. But here your lordship will see, even if I assume that the investigating officer is a key witness, my lord, he is now not posted at Borpata. He is, yesterday they have told that he is an officer in charge of Gwalpara police station. So for election duties, he will not be able to come and they will not be able to release him now. Now, even if he is a key witness to the trial, my lord, but we cannot influence him. He is the investigating officer. His role is only to collect the evidence and to present it before the court. Only next time when he comes, he will prove the exhibit. We'll put the contradictions to him. These are all matters of record now. So that's why I respectfully submit that your lordship will kindly consider the bail at this stage of this accused person, because any further custodial detention will not help them. Neither it will cause prejudice us, because we'll not be able to produce our defense in because that person is during this time. One more aspect, my lord. Initially, when we went to the Supreme Court, my lord, the trial court took an exception that when the bail was rejected by the Supreme Court, you should have you did not surrender before it to the police, but we surrendered before the court, my lord. But that option is always there. We can surrender it before the police or surrender it before the court. We surrendered voluntarily before the court on 7/1/2025. It was not that we have been arrested or warrant. My learned friend, client, he has been allowed to go on bail on during for his medical condition. Now he is again back on jail. And during this entire period of custody, there is not even an allegation that we tried to influence any of the witnesses or we tried to tamper with the evidence. That we have not done, my lord. So considering all these factors, my lord, I have annexed all the evidence, but I will request your lordship not to make any observation on the merits of the case, because that will prejudice us during the trial, and it may prejudice also the prosecution. So that I will not say, but for your lordship's satisfaction, your lordship will find that there was a prior civil dispute. Nobody, because that was the reason. That it was not that we are unknown to that person. Even the eyewitness is a party to the civil suit. Those cases are going on still now.
Okay.
So that's my respectful submission before your lordship. And the next date is fixed on of this case on 25th March. And election, my lord, will not be finished till 2020. And your lordship can take care of all this situation. That I will not, there's now no question of influencing the witness, or I cannot change their statement. Investigating officer, I cannot do. Your lordship can give the stringent condition during this Ramjan month. I think it is on 28th. 2021st. That will be again depend on sighting of the moon. So.
Okay.
And by looking into the evidence and everything, it is not likely that it, although it looks on very rosy picture that only the investigating officer has to be examined, but I don't think it will, trial is likely to conclude in the next 6 months, because we have to give the defense evidence to prove our innocence. Especially, the IO did not seize the CCTV footage to show at what time I left the hospital. He did not make any endeavor. He only confined himself on seizing the mobile, the CDRs and the tower dumping to show that we are looking. One more aspect, my lord. One motorcycle was involved in the incident when when it was alleged that they tried to flee. In this case, your lordship will find that 6 motorcycles have been seized. And no forensics of the motorcycle were done. No MVI report of the motorcycles were done. And the weapon of assault, my lord, weapon of assault, the dao, it was recovered from a river after about 9 days of the incident. And even when the forensic expert came, the IO did not even collect the blood samples of the deceased to compare or to compare that this is the even if there is a trace of DNA in that dao, it is of the deceased. The scientific evidence also doesn't support their case, my lord. And some of the
If
witnesses.
one dam will be flung into the river, water will wash up the.
But they want to show, but from the evidence that
The
normally.
water will wash up any.
Yes, and
forensic
yes,
clue.
yes. What they did, my lord, initially they took this SDRF personnel to that spot in that Becky River. They dived it. They could not find that dhow. Then they found that dhow downstream 3 kilometers away from the place where they initially did that dhow. Now, scientifically, my lord, if you are very advanced, as an officer of the court, I should say that for 9 days, some traces of blood may be there.
Okay, that I know.
There may be there, or it may be also of rust. They did not do any test to determine whether it is of blood or rust. But even if there is some traces of blood in that dhow, then that trace of blood has to be collected with the deceased. That was not done.
Even in water also.
Sometimes the current it is difficult, but for a moment we take it that even for 9 days also it will there if there's blood is there, but there is no connection with the blood of the deceased. And your lordship will find from the witnesses, it was a river. They could have taken independent witnesses. They did not take any independent witness. The SDF personnel said that I did not know from where this dhow had sprang up. One of the seizure witnesses. And 2 of the seizure witnesses have become hostile because they said that the investigating officer has taken our signatures in blank papers. Because at that time, since she was a lawyer, so there was a hue and cry that she was a lawyer. That's why the culprit should get the exemplary punishment. But now, at the end of the day, when we look into the evidence of the trial, we find that she has criminal antecedents. Anyone can. And the saddest part is that these 2 persons who are on bail in this case, who against whom there is a allegation of stabbing and absconding with that accused persons and the hired killers, they are all on bail because the investigation could not prove that they are anyway involved in this case. And there is no criminal conspiracy added to this case. Only the 34 was there. So, there must be some prima facie evidence to, at least at this stage, to ensure further custodial detention. So I respectfully submit that at this stage, your lordship may kindly consider,
I'll
because
have to delve deep into it because I have
yes.
two submissions today. He will also submit, you are submitting, and then PP will also
Yes.
submit.
Yes.
And record is also huge. I'll need some time.
Yes, my lord, your lordship, we have utmost faith in this honorable court. That's why when earlier time when we rejected key witnesses, we had to submit, because last time when your lordship rejected, there was 6 witnesses. So key witnesses, those 6 witnesses will be vital. So your lordship has rejected, and ultimately your lordship's order has been upheld by the Supreme Court, because saying that yes, the learned single judge is right because it is 6 witnesses. But now we have come again only when after all these witnesses are examined and accept the investigating officer. So your lordship will balance the right of the deceased family as well as of the accused in regard to fair trial. And yeah, I'm a person, your lordship will see, I have annexed those documents. An officer of the army who has had decorative service to the country is now behind jail because one witness has said that I was holding the neck of the deceased. And it was not that I was a stranger to them, because they thought that I had a civil suit against them. The 1 crore 40 lakhs, 1 crore 30 lakhs and odd they have taken. That's why they have implicated me.
Okay.
I'm deeply obliged.
One is item number 8 and one is item number
I am
1.
for item number 1, my lord.
I take your lordship, please.
Yes, of course.
In this matter, my lord, initially, Sessions Court allowed me to go on bail.
Mm.
Then Honorable High Court, my lord, rejected my bail prayer. Against that, my lord, I have preferred a bail application. I preferred an SLP before the FX court,
Mm.
and my lord, an order was passed, my lord.
Mm.
Now is a situation wherein, my lord, that the apex court order, it has been, my lord, because this matter is not for the first time, it has come before this honorable court. On the earlier occasion also, honorable court has dealt with this particular case. And in the earlier occasion, I was allowed to go on interim bail considering my health ground. And then subsequently, I surrendered, my lord. And now I am languishing in jail, my lord. But my lord, the basic, my lord, the question that earlier it was taken into consideration, my lord, the order of the Honorable Apex Court, the
Mm.
the order, my lord,
Mm.
the prosecution is, my lord, taking the said order of the Apex Court as an adversarial order, my lord. But what I am submitting before this honorable court, my lord, is that the order was not adversarial order, it was a beneficial order. That only page 46 for a moment, if my lordship again peruse the order.
Is 46 of item number
46
1.
of item number 1, my petition.
Okay.
My lord, para 6, my lord. Notwithstanding the present order, the petitioners are at liberty to apply for fresh bail after examination of the key witnesses, including the seizure witnesses. This is one part, my lord.
But this was not shown to me in the first case, no?
My lordship.
This was not shown to me in the first time where you applied for bail.
No, my lord, shown, my lord.
Shown.
Yes, my lord. And then, my lord, the second part, the state will naturally take steps for early examination of the key witnesses. Now, my lord, the definition of key witnesses is not there in the earlier CRPC, now BNSS, my lord. But, my lord, this order itself is a situation wherein the Honorable Apex Court has granted me an liberty that after examination of the witnesses, I am at liberty to apply for fresh bail. So, when a liberty is granted by an order of a court, my lord, that liberty, that order cannot be taken as an adversarial order. It has to be taken as a beneficial order, my lord. Otherwise, my lord, the order would have had been, my lord, that bail shall not be granted to the petitioners till examination of the key witnesses. But that is not the language of the order, my lord.
Okay.
Now, my lord, after I approached this honorable court, I was allowed to go on interim bail. I surrendered, my lord. Then
I remember this order was shown to me during that case. Let us call for the record. Don't remember.
My lordship.
This order, I don't remember it was shown to me. Otherwise, I would have mentioned in the order.
My lordship, this was, my lord, this is not the first time that I have come, my lord. Earlier also I have come, my lord, and the entire orders were governed by this order only. But the interpretation, my lord, that I am raising it for
When I have granted interim bail,
my lordship.
I don't
Interim bail
remember.
was limited only to the extent, my lord,
that my health was
But why were you
deteriorated.
show me this order of the Supreme Court?
It was there, my lord, but my prayer was
I don't
only,
remember, I don't remember.
my lord.
Let's call for the
Sir,
record.
can I go with the-
I didn't mention in this order. This
No,
order
my lord,
was
I was
not-
only allowed to go on interim bail, my lord. I was only allowed for
I know, but I
medical
didn't mention
examination,
in this order. Let us call for the record to call for the person.
my lord.
Bail application
Now-
2534 of 2025. Record to yellow call kori diba. 2534 of 2025. More order pass kori. All right then.
My lordship.
Mm.
Then, my lord, I withdraw after my lord, I surrendered, I withdraw. And then, my lord, the order that has been passed by the Honorable Trial Court, my lord,
Mm.
the observation, because key witness, that aspect they have taken into consideration. And my lordship may kindly come to page number 119, my lord. Third para, my lord.
Mm.
Third para,
Mm.
seventh line, my lord. The prosecution has examined important official witnesses. So though my bail petition was rejected, taken into consideration that
Mm.
I withdrew the case, I withdrew the bail application and approached the Honorable Trial Court. But my lord, this observation was made that prosecution has examined important official witnesses. Now that is with regard to, my lord, the history of the, my lord, the proceedings so far as the bail is concerned, my lord.
Mm.
Now is the situation, my lord, the prosecution has already examined all the material witnesses except the IO, my lord. And if my lordship may,
Okay. That I know.
my lord,
Because Haskopur has submitted.
my lord, but my,
So no point repeating, you can concede to the.
no, my
part
lord,
of the
my
argument.
stand is altogether, my lord, my case is altogether different, my lord.
Mm.
His allegation is with regard to, my lord, because 3 accused persons were there.
Mm.
My role is only limited to the extent, my lord. Not a single witness has said anything against me, my lord. Neither I was present, nor I was party to any conspiracy. Though conspiracy charge is not there, 34 is there, my lord. Entire evidence, my lord. If just for the satisfaction of this honorable court, if my lordship may permit me to point out the, my lord, evidence for a moment, my lord. Because,
Okay.
my lord,
All right.
I'm highly obliged, my lord. Page 48, my lord, is the PW1.
What is your name?
My name is Mohibul Haq, my lord.
Okay.
Mohibul Haq at Moni.
Okay. PW1.
PW1, my lord, married, my lord. I am the informant in this case. On 21/3/2022 at around 7:30 p.m., my younger sister Rinima Begum took my elder sister Rupjan Nessa near Binoy, doctor of Bilor Tarihati Chowk. After meeting the doctor, Rinima Begum took her driver's seat of her vehicle and Rupjan took the seat near to the driver's seat of the vehicle. At that time, accused Jumma at Abdur Rahman opened the door of the vehicle and dragged out her, and accused Mokdom hold the neck of Rinima. In the meantime, Jumma and Abdur Rahman stabbed with a knife at the abdomen of Rinima Begum. At that time, accused Chintu was near the place of occurrence with his bike. So, bike aspect is important, my lord. Accused Mokdom and Jumma boarded in that bike, and thereafter all 3 were fled away.
So you are Chintu?
No, my lord.
Mm.
I am Mohibul, my lord. So 3 number of bikes were seized in this particular case.
One bike was seized from my house, my lord. And that is the case against me, my lord.
See, 3 bikes were seized or 6 bikes were seized?
3, my lord.
No, Vasco submitted that 6 bikes were seized.
But my lord, my seizure list, three bikes were seized, my lord, not 6, my lord.
All right.
Now, my lord, PW2,
Hmm.
page 52, my lord.
Hmm.
I have a pharmacy near the chamber of Binoy Doctor. On 21/3/2022 at around 7:30 p.m., I noticed one woman shouting, "Hanlak, stabbed." When I rushed near the place, I found one woman with injury near the driver's seat of the vehicle. To our question, the woman who was shouting replied that 3 persons had stabbed the another woman. After some time, police came and took the injured and other person to the hospital. Later, we learned that injured woman succumbed to her injuries. Later, I learned that name of the injured woman was Rinima Begum. She was an advocate. Nothing against me, my lord.
Hmm.
54 PW3, my lord.
Okay. Yes.
My elder sister's house is situated near the clinic of Binoy Doctor. On the day of incident, I was at my elder sister's house. At around 7:30 p.m., I heard shouting near the chamber of Binoy Doctor. After reaching the place of occurrence, I found one woman lying with injury on her person near a vehicle. Thereafter, police came and took the injured woman to the hospital. The name of the injured woman was this much, my lord. Nothing against me, my lord. 54 page number, PW3. PW4, my lord. Accused Mogdom Ali is the husband of my younger sister. On 21/3/2022, police seized one mobile belonging to accused Mogdom Ali from Mogdom Ali in my presence. In this case, police also seized one motorcycle belonging to my younger brother, accused Mohibul Haq, in my presence. So this is, my lord, for the first time, my lord, seized one motorcycle. So this much has come only. 56, my lord, PW4.
Hmm.
Now cross part, my lord, page number 57.
So Mohibul is brother of the main accused Mogdum Ali.
He is the, my lord, brother-in-law of Mogdom Ali. That is why his name has come, my lord. He was implicated. Now 57, my lord. My lord.
Yes.
57 cross for Mohibul, my lord. Mogdom was taken by police on 21/3/2022. The seized motorcycle was in defective condition. Therefore, it was pulled to police station by police, my lord. Page 57. So the vehicle which was seized from me, my lord, it was defective condition and it was pulled to the police station by police, my lord. 3 number of vehicles, 2 Avengers and 1, my lord, aviator, no? Glamour Hero, my lord. 1 Avenger was seized from my house, my lord, and it was not functional.
Okay.
Now PW5, my lord, page 58. Victim Rinima Begum was my related elder sister. In the year 2022, one day police seized one mobile handset from informant Harun Ali in my presence. PW4 is the seizure list. PW4 is my signature. Police also seized some wearing apparels from the morgue of FAMCH Borpeta in presence of PW5 is the seizure list. Exhibit P5 is my signature. Police also seized cut piece of floor mat of the car of deceased Rinima Begum in my presence. Exhibit 6 is the seizure list. P6 is my signature. The seized materials are available in the court today. Nothing, my lord, against me. Page 60, PW6, my lord. Informant Hurun Ali is my husband. This is Rinima was the younger sister of my husband. 21/3, one of my neighbor informed me that Rinima Begum was stabbed at Tarihat. Then immediately I informed to my younger brother Nasiruddin Ahmed. Thereafter, we immediately went to FAMCH Borpeta. We found Rupjan to FAMCH Borpeta. She told us that Rinima had expired. Rupjan told us that Juma stabbed Rinima while Mogdom Ali was holding Rinima with his hands. And after assaulting Rinima, Mogdom and Juma fled away in the motorcycle driven by Sintu. So there was one motorcycle, it was driven by Sintu, and all the 3 accused persons were fled away from the place of occurrence in that bike, my lord. But the bike which was seized from me, no one has identified, no number has been stated by anybody, my lord. And the bike which was seized was, my lord,
not working condition. 3 numbers of bikes were seized by police, my lord.
Okay.
Page 64, PW 8, my lord. He has also said, my lord. Only relevant part I am reading. Thereafter, in the bike of Chintu, both Jumma and Mokdam fled away. I was shouting. In the meantime, gathering occurred at the place of occurrence. After some time, police came.
Okay.
Now, page 67, my lord. 8 para. Page 67, 8 para.
Yes.
I cannot say the color and brand name of the motorcycle in which the 3 accused fled away from the place of occurrence. Eyewitness is saying, my lord.
Okay.
Then 71, my lord. PW 8. About 1 year back, one day, the OC Borpeta police station informed me that they had traced out one bike which was involved in a case, and I was asked to attend the Borpeta police station. Thereafter, I came to Borpeta police station. I was taken to a house at Dangarkusi, and police seized one motorcycle from a house. With police, one Mohibul Haq was also present. Exhibit P2 is the seizure list. P2 is my signature. So this much, my lord.
Okay.
So cross part, my lord, he said, my lord, I was told by the police that the motorcycle was used in a crime. The vehicle gave a starting problem. I cannot ref whether the vehicle was brought to the police station by driving or by pulling. So, my lord, that much. Then, my lord, page 74. PW 10, my lord.
Okay.
On 22/3/2022 in the midnight, police visited my house and seized one Avenger motorcycle belonging to my brother-in-law, Tabibur Rahman, at Mintu. This is another bike, my lord.
Another person.
Then, my lord, page 86, PW 19.
Okay.
Page 86, my lord. About 2 years back, one day police called me to the police station. When I reached police station, police took me to the house of one Rakibul Islam. In my presence, police seized one motorcycle from the house of Rakibul Islam in his presence. So different, another bike, my lord, Rakibul Islam. Then page 87, P20, my lord. This is he speaks about the bike which was seized from Rakibul Islam. PW 20 also.
Okay.
So altogether, my lord, in this case,
23 witnesses were examined.
31, my lord. I have, my lord, annex 29, my lord, to
Now we have the LCR.
my lordship, my lordship.
Mm.
So out of
We have the voluminous LCR.
my lordship.
Mm.
So out of all the 31 witnesses,
Mm.
my role has never come up, my lord, as to what I had done. My role was only limited to the extent that, my lord,
One motorcycle was seized from my house. And in the cross, it has come that it was not in working condition. Two other motorcycles were also, my lord, seized. Altogether, 3 motorcycles, my lord. But all the eyewitnesses, my lord, in consonance, they had stated all the 3 witnesses fled from the place of occurrence in one bike. And the identity of that bike was never ascertained by the prosecution at any point of time. Neither any of the witnesses has said about the number plate of the bike or the makeover of the bike, my lord. So on what basis, my lord, the prosecution can say that it was my bike in which the incident had occurred, my lord?
All right.
And so far as, my lord, CDR is concerned, it has been, my lord, they have brought in, my lord, mobile phones and all, my lord. That also, my lord, my number, I never contacted anyone with my number, my lord, prior to the incident, my lord. And the said prosecution witness cannot shed any light, my lord, with regard to, my lord, the communications that took place. Rather, my lord, one important aspect, my lord, I'll put it, my lord. 102, my lord, PW 28. He said, my lord, he was the constable and he was allotted the duty to, my lord, find out the CDR and see whether any, my lord, suspicion communication that took place. However, my lord, in his chief only at page 103,
Okay.
third para, last line, my lord, page 103.
Okay.
He said, I did not find any suspicious conversations using SIM card of Airtel and Vodafone.
Okay.
So now, this is the sum and substance, my lord. I have
Mm.
placed the entire case before your lordship, my lord. My case is very limited, my lord. There is not a single allegation against me that has come up in all the prosecution witnesses, my lord. So under that circumstances, since last more than a year, my lord, I am languishing in jail. Now, my lord, earlier when the apex court said, my lord, to surrender, my lord, I was not properly informed on 12th. Then that order was dismissed. I was not known about the order, my lord. 6/1/25, I appeared before the police. They said I was arrested, my lord, just after 20 days, my lord. And that is why, my lord, an imputation was raised that I tried to fled away, my lord. But that is absolutely not there, my lord. Because subsequently, my lord, when I was granted interim bail for my medical emergency, my lord, my conduct clearly reveals, my lord, that I duly surrendered before the court on the date so fixed by the honorable court, my lord. Only one aspect, my lord. Now, there are, my lord, various Supreme Court judgments, my lord. If my lordship may allow me to place only one judgment, my lord, I'll not take much time of this honorable court. Let me just very my lord, para 21, my lord. 2012, 1 SSC, 40, my lord.
Okay, this one I know that.
My lordship.
2G case.
My lordship, my lordship. Only, my lord, para 44, my lord. It says, my lord, in deciding bail applications, discussing about another order, my lord. In deciding bail applications, an important factor which should certainly be taken into consideration by the court is the delay in concluding the trial. Often this takes several years, and if the accused is denied bail but is ultimately acquitted, who will restore so many years of his life spent in custody? In Article 21 of the Constitution, which is the most basic of all the fundamental rights in our Constitution, not violated in such a case? That is question mark, my lord. Of course, this is not the only factor, but it is certainly one of the most important factor in deciding whether to grant bail. So that my lord, I raise a question, I put a question to myself, my lord. If tomorrow, because considering the facts of this particular case, my lord, so far as my limited role is concerned, absolutely I have placed, my lord, there is nothing against me. So if tomorrow, my lord, I get an acquittal, I have a minor daughter, my lord, and two daughter, and tomorrow if I get acquittal, who would restore the that period of time that I spent behind the bars and not with my daughters, my lord?
Okay.
And that particular point of time when the Supreme Court order was, my lord, passed, directing me to, my lord, giving me to appear, my lord, that time my wife was pregnant. And that is why, my lord, the entire situation took place. My counsel informed me not to, my lord, take tension. And that is how, my lord, the entire incident happened. But, my lord, that I'll not submit now, my lord, because what is there on the papers, my lord, that only I can point it out, my lord.
All right.
My lord. So my submission is that much, my lord.
My lord, before coming to the facts and the merit of the case, my lord, in both the case, item number 1 and item number 8, my lord, I am coming to the chronology of the bail order, bail rejection order, and numbers of SLP file, my lord, to make the things clear, my lord. Now, my lord, in item number 1, my lord, and there is item number 8, maybe some orders are not annexed in the petition of item number 1, maybe some reasons, or maybe left, my lord. So, my lord, in the chronology of order, my lord, there is one order 29/6/2022, my lord, passed by the learned session judge, my lord, whereby both the, my lord, the accused petition.
Page number? Item number?
Yeah, my lord, in item number 1, this annexer is there, my lord.
Page number?
Both, my lord, here, my lord, the annexure is, my lord, to page 24, my lord. Page 24, annexure is 2, my lord.
Mohibul's case, no?
My lord, both, my lord, both, my lord. Both were granted together, my lord. Both were granted together. It is applicable for both the cases, my lord, item number 1 and item number
Page 24.
8. Yes, my lord. Earlier they are together, later part, my lord, one came, one is not in other side, my lord. Now, my lord, that is in, it is available in, my lord, item number 9 also. Both I can give the other, my lord, list also, my lord.
I'll take one only.
Yes, my lord. Now, my lord, there is a bail granted by the learned session judge. Page 24 is annexure 2, my lord. Thereafter, my lord, aggrieved by that, my lord, that is the bail, my lord. That is granted to both the accused petitioner, my lord. Inform and approach before this Honorable High Court by way of filing an interlocutory applications for rejections of the bail grant. Now, thereafter, my lord, that particular bail granted by the learned session judge was, my lord, rejected by this Honorable High Court on 25/2024, my lord. That is annexure 3.
25?
25/2024.
25/2024?
24, my lord.
Page?
That is annexure 3, page 26 of the, my lord, this is item number 1's petition, my lord.
Okay.
Yes, my lord. Now, my lord, being aggrieved by this, my lord, that is the order passed by this Honorable High Court, my lord. Both of them, my lord, that is the accused petitioner in both the cases, they approached before the Honorable Supreme Court by way of filing a special leave appeal, my lord. And that was, my lord, also, my lord, dismissed. That is on 25 to, my lord, that is dismissed, my lord, that is in the annexure 4, page 45, my lord. Annexure 4, page 45 of the item number 1, my lord.
Page 45.
Yes, my lord. That is already my learned friend has gone through that, my lord. And what are the guidelines? What are the
dismiss the SLP?
Yes, my lord. Yes, my lord. What is there, my lord? That is, my lord, reflect. Now, my lord, After that, my lord, that is that order, my lord, that is the, my lord, annexure for page 45 order, what is relied on, my lord. Thereafter, my lord, the chronology is that, my lord, 25, that is order, my lord, that is, my lord, against where, my lord, the special leave appeal was, my lord, dismissed, my lord. That is order may be, my lord, recorded. That is the order dated, my lord, 10/12/2024, my lord. On that particular date, my lord, it was dismissed, my lord. It is in page 45, my lord.
Okay.
10/12/2024, my lord.
Mm.
Now, my lord, after 10/12/2024, my lord,
Mm.
another bail application was filed by both the, my lord, petitioner together
Mm.
before your lordship. That is, my lord, bail application number 716/2025. I didn't notice, my lord, that bail order in item number 1, but that order is very much available in, my lord, item number 8, my lord.
Page?
My lord, 716/2025 in item number 8, my lord, it is, my lord, annexure 9, page 145, my lord. Page 145, my lord.
Item number 8, page 145.
Page 145, my lord. Page 145, my
এইটো
lord.
হেৰি আজি
আৰু in-
খন দি দিবা দেই দুটা মাৰ্ক কৰি পেলাই নতুন আইটেম নম্বৰ 1 আৰু আইটেম নম্বৰ 8 কজ লিষ্ট খন দি দিবা এই অৰ্ডাৰটো ৰিজাৰ্ভ কৰি থৈ দিম যে
8, Mogdam আৰু Mohibot,
কজ লিষ্টটো লাগিব
24/4/2000.
পেজ নম্বৰ 145 আইটেম নম্বৰ 8 পেজ নম্বৰ 145
Page number 145, my lord. Bail application 716/2025.
সেইটো মই অৰ্ডাৰ কৰিম লাগিব এইটো পাছত লাষ্ট অৰ্ডাৰ দিনাখন নহয় অৰ্ডাৰ দিনাখন দি দিম সেইদিনাখন চেক কৰি ল'ম পেজ 145
Yes, my lord. 145 of item number 8, my lord. This is my both together, my lord. Mogdam Ali and my lord Mohibul Haq, my lord. Both together, my lord. Applied this bail petition, my lord. And my lord was pleased to, my lord, that is reject that petition, my lord.
Mm.
That is on, my lord, 24/4/2025, my lord. 24/4/2025, my lord.
Okay.
My lord, after that, my lord, being aggrieved by this order, my lord, of the, my lord, rejection of the bail, my lord, on 24/4/2025, both the petitioner, my lord, approached before the Honorable Supreme Court by way of filing a special leave appeal. That is, my lord, the page 153 of item number 8, annexure 20, my lord. Annexure 20. Where, my lord, on annexure 20, my lord, the honor,
53 okay.
yes, my lord, 153, my lord, page 153, annexure 20, my lord. For both, my lord, both went to the Honorable Supreme Court, my lord. The Honorable Supreme Court was pleased to, my lord, dismiss this petition. My lord, very short, my lord, that is the order, my lord. May I read, my lord?
Yes.
Very short order, my lord. The petitioner challenged the judgment and order dated 24/4/2025. That is, my lord, that is the bail application number 716/2025. In bail application 716/2025 passed by the Gauhati High Court, titled Mogdam Ali and another is that is Mogdam Ali is item number 8, another is Mohibul Haq, that is item number 1, my lord. We have heard learned counsel for the petitioner. Having considered the contention made across the bar, we do not find any reason to grant special leave to appeal. As such, the present special leave petition is dismissed. My lord, that was. Now, my lord, meaning thereby, when I approached before the Honorable Supreme Court 2 times, one against the bail cancellation order by the Honorable Supreme Court, again against an regular bail application which is filed and, my lord, dismissed by this Honorable High Court, then thereafter only that is the Honorable Supreme Court's order, which is what is prevail on date, is, my lord, that is 16/7/2025, annexure 20, 153 of, my lord, that is the item number 8, my lord. where both are there, my lord. That is the, my lord, latest position, my lord. Now, my lord, before that, my lord, coming to that order, my lord, that is, my lord, dismiss, my lord. What is in the, my lord, that is the bail application number 716/2025, my lord, which is, my lord, assailed before the Honorable Supreme Court. Only, my lord, 2 lines, my lord. I'm going to, my lord, read it out. 151 page of the, my lord, that is the item number 8, my lord. 151 page, my lord. My lord, the last 3 lines, my lord.
Yes.
Yes, my lord. However, an opportunity was granted to the petitioners to apply fresh bail after examination of the key witnesses, including the seizure witnesses. It was already been held in the foregoing discussion that the witness who are yet to examine cannot be dismissed as unimportant witness. That was the observation of this Honorable High Court, and being agreed by this observation, my lord, they approached before the Honorable Supreme Court, and that was dismissed. That is the position, my lord. When, my lord, that is the order dated 16/7/2025, that is the when, my lord, that SLP was filed, automatically as on today, that is the, my lord, what is the Honorable Supreme Court's, my lord, that is the order direction, what is available with us, that is the latest position, that is only 16/7/2025.
Okay.
And these 2 orders are available in, my lord, item number 8, my lord. Now, my lord, after that, my lord, when, my lord, Supreme Court dismissed that, my lord, that is meaning thereby, what is my limited understanding is that all the witnesses are taken as a key witnesses, my lord, including the IO, my lord, which is not, my lord, examined in the last occasion, what my learned senior has submitted in his, my lord, that is a submission, my lord. Now, thereafter, my lord, that is, my lord, SLP, that was, my lord, ordered on, my lord, that is 16/7/2025. Thereafter, my lord, that is the, in item number 1, my lord, that is the Mohibul separately filed. To that effect, my lord, they are together, my lord. They were together, my lord. Now, another, my lord, bail application 2534/2025, my lord, that is Mohibul Haq, my lord, filed, my lord, and that is available as, my lord, annexure 9, my lord, page 112 of the item number 1, my lord. Where, my lord, was pleased because of his medical ground, my lord was pleased to give him some interim relief, my lord, and thereafter, my lord, as because this, my lord, as it is withdrawn, my lord, may not be there, but I am very much sure, my lord, that because, my lord, that order is there, my lord, there is no, my lord, kind of, my lord, that is, my lord, that is the violation of the, my lord, verdict of the Honorable Supreme Court, because whenever, my lord, 2534/2025 is there, that is the latest, my lord, the order of the Honorable Supreme Court is, my lord, that is the special leave appeal, that is, my lord, where the order is passed on 16/7/2025, my lord. What is available in, my lord, item number 8, my lord. Now, my lord, regarding the part of the, my lord, that is the trial, my lord, only my humble submission before your lordship is that, my lord, is very much aware in, my lord, many cases, my lord, I am not relying on those judgment. Even, my lord, state of Karnataka versus Darshan, though it is, my lord, regarding the cancellation of bail, very categorically, my lord, it is discussed, my lord, in the stage of trial, my lord, so that, my lord, there should not be any prejudice, my lord, for both the sides, my lord, it should not be taken as a mini trial, my lord. That is only my humble submission, my lord. Now, my lord, the facts remains is before your lordship, my lord. There is already, my lord, all the witnesses to be examined. Only the IO's part is left, my lord. And the case before your lordship is that already, my lord, decided there is the all key witnesses, all witnesses, my lord, even, my lord, that is the IO is also a key witness. So, my lord, this is the last stage, my lord, and there is no inordinate delay in the part, my lord, in this case, my lord. That is, my lord, the 2G spectrum case where, my lord, it is clearly stated, my lord, years and years. It is not a case where, my lord, there is the years are there, my lord, and no witness are examined. So, my humble submission before your lordship is that it is in the end stage, my lord. At this stage, my lord, if it, my lord, will be granted, my lord, because already it is decided, it will, my lord, prejudice, my lord. That is the, my lord, right. That is my humble submission.
My lord, only I just want to place my lord and reply to two points, my lord, that has been raised by my learned friend for the prosecution side, and the honorable court also raised one point, my lord. One, my lord, my learned friend has said that I have not pointed out with regard to the order dated 24/4/2025. In my petition at page 7, paragraph number 11, I categorically stated that, my lord, after perusal of the record, Fridays order dated 24/4/2025 was pleased to hold that at the fag end of the trial, the honorable court was hesitant to grant bail to the petitioner. We to mention herein that honorable court, though otherwise observed that the merit of the case was not brought to the fore by the petitioner as the trial is still under progress. So merit of the case was never discussed by this honorable court. And I had categorically made a statement at para 11, page 70, page 7, with regard to the submission made by my learned friend that I had not pointed out with regard to the order passed by this honorable court, by order dated 24/4/2025.
Okay.
Now, so far as my lordship has also raised one question that, my lord, whether I had placed the order earlier order of the honorable apex court before this honorable court while approaching the honorable court.
Maybe you have placed, but you have not shown
I,
that
my
order
lord,
to me.
At page 6, my lord,
Hmm.
para 10, my lord, I had,
You have not shown to me. I will remember if there is an order passed by Supreme Court.
my lord, it was the series of the case, my lord.
Hmm.
And in my pleadings, my lord, my case was very limited, only to the
I
extent.
only remember that he was not ailing.
Absolutely, my lord. That much was my, in fact, in my prayer portion also, my prayer was only limited to the extent that I
It's
want
okay,
to
it's
get some
okay.
medical examination, and that is why I.
Maybe you have pointed out, I have not, I cannot recall,
Because-
maybe it's been several days.
My lord.
So it's okay, it doesn't matter.
My lordship. Now, my lord, my learned friend has submitted with regard to the procedural aspects, my lord. It is there, what order is there, what order is not there, is it subject matter of the record, my lord. But, my lord, the most important aspect of this particular case, which on the earlier date 24/4/2025, my lordship has categorically stated that without going into the factual aspect of the case, now considerable statements have already been examined. Only left is the IO, my lord. And, my lord, the factual
That you have
aspect,
submitted, no?
my lordship, with regard to what I am pointing out, my lord, the prosecution is not pointing out that this particular, my lord,
That you have
material is
submitted, no?
against me, my lord. It is not there on
That you have
record.
submitted. Harry, number 1 to Tifa Hard Learned Counsel, Mr. M.K. Das,
My lordship.
for the petition, and Learned Additional PP, Mr. K. Busha, for the respondent state, fixed for the detailed delivery of order. Ako itu লিখি দিবা, number 8, Hard Learned Senior Advocate, Mr. B.D. Kwa, আৰু বাকি এনেকে দি থৈ দিবা। আৰু দুইটা একেলগে দি পেলাই এইটো ইয়াত হেৰি গাঁঠি দি দিবা।
Only,
আৰু এইটো লাগিব। Yes, yes. You were saying something, yes?
my lordship, only aspect is, my lord, at this stage also, there is no bar that honorable court cannot consider my bail application, as pointed out by my learned friend, that it is a violation of the honorable apex court's order. It is not a bar, my lord. It cannot be a violation of an honorable apex court's order, my lord. Because leave was not granted at the subsequent order that I have annexed.
Okay.
Deeply obliged.
One to লগাই দিম, serially যাওঁ।
9, can it be taken up at 2, lordship?
Yeah, unfortunately, both the counsel in this case have expired.
Expired.
Have expired, both the counsel. So I am entering appearance for petitioner, trial power today.
Item number 2.
2, my lord. Both the council expired, my lord.
Okay. Item number 2, no? Okay, SR Rabha has passed away, no?
And J dash also passed away.
Okay. You are taking the brief.
No,
So you'll submit today or you'll take an
my
adjournment?
lord, I've just entered today only, my lord.
Okay.
Can it be after some time, my lord?
Okay, you have filed a color number?
My lord, today.
Learned counsel, Mr.
B. Chakraborty.
B. Chakraborty has submitted that as the learned counsel, Mr. J. Das and Mr. S.R. Rabha have passed away. He has submitted the Wakalat Nama to represent the appellate or petitioner. Whose learned counsel, Mr.
V.K. Borwa.
V.K. Borwa is present for the respondent. Full stop. An adjournment is sought on behalf of the an adjournment is sought by the learned counsel for the petitioner. List this matter after
2 weeks, my lord.
2 weeks. Okay.
And the interim order passed earlier, my lord.
Interim order shall remain in force till the next date of listing.
Alia blast.
I have a submission, my lord. I have an instruction from my client.
Hmm.
If they are agreeable to that. This is a very simple husband-wife tussle, my lord.
Hmm.
Can it go for mediation? The mediation drive is going on, my lord.
Of course.
I think, my
I will
lord,
take instruction, my lord, because the
let it be after 2 weeks, then both sides. will-
Okay, then you come after 2 weeks, or we can refer to mediation. Kodiba, section of Kodiba, mediation of current DD. Okay, all right.
But-
Lordship, so sorry, we are so sorry, Lordship. We have mistakenly mentioned it for adjournment. Item number 3, regarding item number 3. Lordship, my senior is not well from last 1 week. She came yesterday, but she again feel not well. So Lordship, kindly adjourn this matter for today.
Already adjourned.
Lordship, we could not contact the other party. Lordship, we have no contact number. That's why, and we didn't take any consent.
কিন্তু adjournment লৈছে না?
Lordship,
It's okay.
highly your place.
Item 4.
Repeat, Lordship. Also, this is statutory appeal and we have filed on the ground of quantum. So we are ready to deposit 50%. That may be released in favor of them.
I লিখিবা, huh? Learned counsel, Mr.
Asham.
R. Sharma is present for the appellant stroke applicant. Insurance company,
Insurance company, Lordship.
insurance company and learned counsel.
Aike Buragohai on behalf of R. Hazarika. Aike Buragohai.
I.K. Buragohai is present.
For respondent number 1,
Learned counsel, Mr.
Mr.
R.
R. Hazarika.
Mr. R. Hazarika, representing the claimant.
Respondent number 1.
Payment.
Representing the claimant for respondent number 1, full stop. This application is filed with prayer to stay the operation of the judgment and award dated 4/1/2025 passed by the learned member MACT Tribunal, MACT Nogao in MAC case number 187 of 2022. Full stop. The insurance company is aggrieved by the judgment and order of the tribunal. And they have submitted that. The insurance company, on what grounds you are
On quantum,
for stay?
Quantum.
Is agreed by the quantum of compensation here. Dated to be paid by the insurance company to the claimant, full stop. Considering the submissions at the bar, the operation of the judgment and order dated 4/1/2025 in MSC case number 187 of 2022 is stayed until further order, subject to the condition that the insurance company deposits 50% of the compensation awarded to the claimant within 2 weeks from the,
Lordship, 4 weeks. I think.
within 6 weeks actually.
Lordship. 6 weeks.
2 months, no?
Lordship. 4 weeks, Lordship, I get.
Within 4 weeks from the date of this order, and on submission of the learned counsel for the claimant is directed to withdraw the money withdraw the amount from the registry
Registry
of
of-
this court. Full stop. The insurance company is directed to deposit the claim of the compensation before the registry of this court. Full stop. The registry may allow the claimant to withdraw the 50% of the compensation after proper verification of the claimant.
Lordship, I admit this appeal.
Hmm?
Appeal may be admitted.
Yes.
Appeal memo may be-
লিখি দিয়া দুজনৰ নাম লিখি দিবা তাৰপিছতে এইটো ডিছপ'জ হয় ইন টাৰ্মছ অফ দি আবাভ অবজাৰভেশ্যন দিছ এপ্লিকেণ্ট ষ্টেণ্ডছ ডিছপ'জড অফ এইটো ওপৰত লিখি দিবা দুজনৰ নাম লিখি দিবা কোৱেণ্টাম এগ্ৰিড বাই দ্য কোৱেণ্টাম কেছটো লিখি দিবা এডমিট লিখি দিবা ইছ্যু ন'টিছ টু দ্য ৰেছপণ্ডেণ্ট returnable within respondents, no?
Response number 2 and 3, Lordship, by usual process.
Issue notice to the respondents number 2 and 3 as per usual process returnable within 4 weeks. The learned counsel for respondent number 1 has accepted notice on behalf of
Lordship.
the respondent and thus no further notice is required to be issued. মিলাই দিবাচোন ৰেজিষ্ট্ৰি অফ দিছ কোড আগতে লিখি দিবা থাকি গ'ল চেণ্টেন্সটো মিলাই দিবা
May I please, Lordship, I am appearing for appellant's claim. Lordship, we prefer this appeals for enhancement, Lordship. Enhancement, Lordship.
learned counsel Mr.
AU Ahmed on behalf of.
AU
claimant
Ahmed is
society.
present on behalf of the learned counsel Mr. AU Ahmed is present for the appellants. Full stop. Issue notice to the respondents returnable within 4 weeks. Admit. Call
Lordship,
for the
respondent number 3 earlier appeared, Lordship.
uh,
Their appeal.
Respondent number 3.
Respondent number 3.
But there's nothing in this here. So you'll have to issue notice in appeal. Admit. Call for the trial court records. Yeah, I go to লিখি দিবা দেই trial court record no records from the tribunal original records from the tribunal আগতে লিখি দিবা এইটো লিখি দিবা list after 4 weeks লিখি দিবা issue notice to the respondent returnable within 4 weeks as per usual process.
Yes, Lordship.
Item 6.
May I please, Lordship, the MSA appeal agree with the dismissal of the judgment, Lordship.
Lordship, I'm appealing for respondent number 1, but I have not received the memo of appeal, I think. Delay was there,
I
it was
thought was-
condoned, it was condoned already.
Okay. Learned counsel Mr. N. Ahmed
And
is present for the appellant. Learned counsel Ms. M. Chaudhary is present for respondent number 1.
One minute.
number 1.
Learned counsel Mr.
T Uddin.
T. Uddin is present for respondent number 2. Full stop. Any more respondents?
No,
No.
Admit this appeal. The appellant is directed to furnish copies of appeal memo to the respondent number 1 and 2. You have received? Call for original records from the tribunal list after 4 weeks.
must apply.
Item number 7.
If my learned friend is coming for the time being, it will be actually, this is also for admission and 50% deposit also. It can be passed also. For the time being, it will, for the time being, or it can be admitted also. And for the respondent claimant also.
We'll pass an order together. Let him come. 7, no? Let him come.
That please. The charge sheeted case, Lordship, and POCSO 12 is there, Lordship. POCSO 12.
We,
My
and
lord,
others-
service completed, my lord. Amicus may be appointed. We
Okay.
get a, my lord, that is information. My lord,
we'll have to appoint
It
an
may be-
amicus curiae.
taken as a part of the record.
Item number কিমান আছিল এইটো?
10.
Item number 10.
9 to হৈ গ'ল নি?
My lord, 9, I am going through the, my lord, TCR, my
Okay,
lord.
okay,
Needs some time, my lord.
Learned counsel Mr. F. Hawk is present for the petitioner, full stop. Learned counsel, learned additional PV Mr. K. Bosho is present. for the respondent's date, full stop. It is also submitted by the learned additional PP that notice has been served to the respondent number 2.
Mojahirul Islam. Yes.
And he has submitted the service report,
Yes, my lord.
a copy of the service report before this court, full stop. Registered to appoint a legal aid counsel, amicus curiae or legal aid counsel?
Amicus, ma'am.
Amicus curiae to represent the respondent number 2. List this matter, when do you want?
Short date, lordship.
Short date, that
Trial already start.
5th March.
Obliged, deeply obliged.
Item number 13 for orders.
No, please, your lordship.
You are for whom?
I am the defendant, respondent.
Respondent,
Yes.
single, sole respondent.
No, your lordship. I am appearing on behalf of respondent number 328, except 2.
Respondent number 328.
328, except 2. And kindly allow me 4 weeks time for filing the wakalatnama on behalf of legal heir of respondent number 1A to 1C.
Meet with your lordship. Apologies, your lordship. The service isn't completed, your lordship.
All.
No, your lordship.
Yes, your lordship. As per,
Respondent number 2.
as per office note 28/8/25, your lordship.
Learned counsel, Mr.
S. Diffusa, your lordship, appearing on
S.
behalf of S. Diffusa, appearing on
Diffusa.
behalf of D. Chaudhary, your
is
lordship.
present on behalf of learned counsel, Mr. D. Chaudhary, representing the petitioners. Learned counsel, Miss
M. Bhattacharjee.
M. Bhattacharjee is present for respondent number 328 and has prayed for time to file wakalatnama on
On
behalf
behalf
of
of
respondent
respondent
number.
1, legal heir of
Legal heir of
respondent number
one.
1A to 1C.
Legal heirs of respondent number 1A to, these are the legal heirs.
Yes, your lordship.
Or file respondent number 1 लिख दे. Wakalatnama on behalf of respondent number 1, full stop. What about respondent number 2? Somebody else, no?
Yes, it's different, your lordship. But as per justice service is completed, your lordship.
Okay. But to come back to orders column. She'll have to file wakalatnama.
But I may be disposed of yours. It's a substitution since they are appearing for the substitution of legal heirs. I had 2197, your lordship.
Just a moment. Notices were served to respond number 2, no?
Yes, your lordship.
But there's an order here on 9/5/2025. But 17/5/2025 office note reveals that notices were served. Notice issued to respondent number and 2 through justice service by the, okay. लिख दिया, office note and dated 17/5/2025 indicates that notices have been served to respondent number 2. The respondent number, full stop, the respondent number 2 is not represented today. What about this IA? You were saying something.
It's for substitution of the legal heirs of respondent number 1.1, Mustafa Arju Begum, your lordship. It expired on 19/5/24. Yes, 1.1, your lordship.
You want to file wakalatnama for whom?
Respondent number 1A, 1.1A to 1.1C.
1.1A,
Two.
1.1
C.
C.
Legal heirs ABCD.
ABC. And your lordship, 1 IA is there.
IA number
2395.
2395.
2365.
65, your lordship. Which,
This is the IA he's talking about, I believe.
yes, I.
Yes, 2365. Learned counsel, Mr. Once
S.
more.
Diffusa.
लिखी दी वहाँ, is present for behalf of learned counsel Mr. D. Chaudhary, representing the applicants. Full stop. Learned counsel Ms. R. Bhattacharjee.
M. Bhattacharjee.
M. Bhattacharjee is present for respondent number
1
number 328
328.
and respondent number.
1.1A, 1.1B, 1.1C.
She has not filed wakalatnama.
They will be filing.
328. full stop. Through this application, the learned counsel for the applicant has prayed for substitution of the legal heir of respondent number 1 within bracket 1, Mosmot Arzu Begum, who passed away on 19/5/2024. Full stop. The names of the legal heirs are as follows. Page 6, para 3A, B, or C, huh? এই নামকেইটা আছে। I've considered the submissions at the bar and therefore the prayer to substitute the legal heirs of respondent number 1 within bracket 1 is allowed. And amended cost title to be filed,
Yes.
submitted.
Yes.
Oh, main case. Main case to আগৰ order to দিছিলো যে or list of date to দিয়া নাই ন 4 weeks
4 weeks.
main case লিখি দিব
You have to date may be fixed, Lord, if possible.
date এটা read আছে
Obliged, Lord.
This is an appeal filed by the institution.
we'll admit it. He's
I am for
asking,
the respondent claim.
he's asking for, I think that,
We'll deposit a 50%.
yes.
But Lordship-
If they want to withdraw it by furnishing bond, let's say. Indemnity.
Lordship, this is only for quantum, Lordship.
Okay. Learned counsel, Mr. Mr. K.K. Bhatra is present for the insurance for the applicant, I to Likiba, and learned counsel, Mr. A.R. Agarwala is present for the claimant. Who stopped the, on what basis you are agreed by the order?
Let's say against the driving license, let's say.
They agreed, the applicant is agreed by the judgment and order dated so and so passed by the learned MSCT.
MSCT 2.
MSCT to Kamrup in MSC case number 517 of 2018, 7/12/2012, 22 days judgment dated, as the driving license of the driver of the offending vehicle was not valid
That's it.
at the time of the accident. The prayer of the applicant to stay the operation of the impugned judgment and order is allowed, subject to the condition that the applicant deposits the 50% of the compensation awarded to the claimant within 6 weeks
6.
before the registry of this court.
Yes, Lordship.
Who stop the learned counsel for the, or the claimant.
Claimant number 1, Lordship.
Huh?
Claimant number 1.
The claimant number 1 is allowed to withdraw the deposited amount from the registry of this court, subject to the condition that the claimant number 1 executes a bond and the registry, after proper verification and identification, can allow the claimant number 1 to withdraw the
But
deposited
punishment
amount.
is also the indemnity amount.
Indemnity bond লিখি দিয়া। Bond is left.
Lordship, I have to receive the copy of the appeal memo, Lordship.
So I shall.
That may kindly be recorded, Lordship.
MSC appeal to লিখি দিবা, একেখিনি কথাকে লিখি দিবা, admit লিখি দিবা, issue notice to respondent number, how many respondents? You are respondent number?
1, 2.
There are 4 respondents.
4 respondents.
I have to take step upon respondent number 3 and 4.
2, 3, and 4. Or
And
to
3 and
issue notice to respondent number 2, 3, and 4.
No,
First
3 and 4.
Or
One and
3 and
yes,
4.
yeah.
Claimant 3 and 4, full stop.
Copy
The
to.
appellant is to furnish copy of the appeal memo to the claimants.
Obliged.
List after 4 weeks.
Date, Lordship.
Call for the to লিখি দিবা।
Lordship, date give it.
Date and video. Call for the original records from the tribunal.
On 1st of April.
Much will.
I have to dispose of it.
Item 14 are orders.
Petitioner, my lord.
Mm.
As per notice, office note dated 8/9/25, unsubmitted notice has returned for respondent number 5, and neither ID card nor unsubmitted notice have returned for respondent number 6 till date.
Mm.
So, my lord, we may kindly be allowed to take fresh steps against respondent number 5 and 6.
Okay, 5 and 6.
Yes, ma'am.
Learned Counsel Miss R.P. Sharma.
Yes, my lord. G. Puri, on behalf of Mr. M.R. Adhikari.
What is your name?
G. Puri,
G. Puri. Learned Counsel Miss G. Puri is present on behalf of Learned Counsel Mr.
M.R. Adhikari.
M.R. Adhikari. Full stop. Learned Counsel Miss
NB Kasta for respondent 2.
N.B.
Kasta.
Kaisto is present for respondent number 2. What about 3 and 4? Not present today. Full stop. The office note dated 8/9/2025 indicates that notices have not been served to the respondent number 5 and 6. Full stop. Applicant may take fresh steps to issue notice to respondent number 5 and 6. Returnable within 4 weeks. List accordingly.
Lordship, since last 2 occasions, the respondents failed to appear. In that event, the IM can be disposed of by making the interim absolute till disposal of the CRP. We were given interim protection by order dated 23/20.
Just a moment. IA number?
I number 2880 of 2022.
On one date they have appeared in this case.
Earlier, they have appeared. Since last 2 dates, they are appearing. Okay.
Okay, we'll fix this matter for hearing then.
Yes, I may be
Okay.
disposed of.
No, we'll list the IO together. Interim orders there, it will continue. We'll fix this for hearing.
They were supposed to file objection in respect of the I.
Not required. They are not present, not required.
Lots of.
Learned Counsel Miss
V. Rai.
D.
V. Rai.
B. Rai, no?
Lots.
এইটো হেৰি CRP টো লিখিবা হা দুইটা একেলগে ক্লাব কৰি লিখি দিবা Your name is not in the cause list?
Yes, Lordship, I'm not on record. I'm appearing on behalf of Mr. S.P. Roy.
SP Roy. Learned Counsel Miss B. Rai
Right.
is present on behalf of Learned Counsel Mr. SP Roy, representing the applicant and the petitioner, full stop. The respondent is not represented today. Respondent or respondents?
There's one respondent.
Respondent is not represented today, full stop. In connection with IA 2880 of 2022, the respondent was continuously absent. Despite the fact that the respondent had submitted that they would file objection, full stop. Considering or this court, considering this court had already passed an order after considering the continuous absence of the respondent, that the civil revision petition be listed for hearing, whose had order dated 16/12/2025, full stop, thereby list the civil revision petition number 55 of 2017 in the hearing column. To some meanwhile, the interim order in connection with IA number 2880 of 2022 shall continue till the next date.
Deeply obliged.
Hearing column or DD? Oh, date এটা এইটো পুৰণা মেটাৰ হয় ন 22 list this hearing or date এটা hearing on 19th of March. List this matter for hearing on 19th of March.
Deeply obliged.
Item 18. Item 18.
Parties are not represented. Parties na right? So I'm going on maybe. Petitioner is not represented to the list after 2 weeks.
Item 19. Item number 19.
Parties are continuously not represented since 29/7/2024 and 10/4/2025. Please go dismiss Korean. List after 2 weeks.
Item 20.
On further absence of the petitioner, necessary orders may be passed.
May I please, Your Lordship? Lordship, in this case, steps were taken on both the respondents. However, on respondent number 2, there is an office note as well as a note by the Jari Karak, Your Lordship. The respondent number 2 did not receive notice stating that his surname is not the same. He is not the person he is named in the surname.
I'm for the respondent number 1, Lordship.
One.
So 2, they have refused, saying that the surname is not correct. Thereafter, I have ascertained, Your Lordship, even in the plaint and in the title suit, the same surname is there. Still, they have not received notice, Your Lordship. The Jari Karak's note is there in the second file, Your Lordship. There is a flag.
But there's an order here, no?
Yes, Your Lordship. On the previous
26/5/2025.
date, when it came up, Your Lordship, I took time to inquire whether the same surname is there or not. I have inquired, and I also from the plaint and the miscase, Your Lordship, that I have filed before the lower court, the same surname is there. The plaint is also annexed at page 16. Harendra Bosumatari is the defendant number 2, son of Saniram Bosumatari.
Harendra Bosumatari.
Son of Saniram Bosumatari. The Jarikarak's note, they have refused and they have not also stated what is their actual surname. They are saying that my father's name, surname and my surname does not match.
জাৰিকাৰকৰ নোটটো ক'ত আছে নো?
The yellow one is there's a flag mark. Yellow flag strike.
Address is not found.
That is postal. If I may help you, Lordship. Page 16 is otherwise the plaint which shows the name.
What is your submission now?
Lordship, that may be presumed, Your Lordship. They have refused.
Deemed to be served.
They have refused it, Your Lordship.
But the notice does not say refused.
They say that my name
Refused,
is
then it's deemed to be served.
Yes.
Refused, then it's deemed to be served.
because they are in knowledge of that there is a suit pending, Your Lordship. Now, for the fact that they are saying my surname does not match, I will not receive the notice. But the fact that this case is pending here before this court is not in the knowledge of them, Your Lordship. And they are also taking part in the trial, Your Lordship. This is against a miscase for injunction, Your Lordship. In the trial, they have participated. And temporary injunction was not granted. Against that, I am before this honorable court.
But their father's name is also correct.
As per the plaint, it is the same, Your Lordship. The plaint is at the plaint as well as the miscase, Your Lordship. Page 16 is the plaint. An extra one.
And this speed post,
That is also probably refused. They say it is not found because
address is not found.
Lordship. But they have said that maybe they have told the peon that my name is not the same.
Page 16.
Page 16 is the plaint.
CPC খন দিবা নে? So, father has passed away now.
Father has
Yes,
passed away. He was the
earlier it was Sri Saniram Basamatari, now it is late Saniram
late Saniram
Basamatari.
Basamatari.
Passed away.
Passed away.
Father must have passed
In the
away.
plaint, it is Sri Saniram Basamatari.
Mm. Page 16 is the plaint, no?
Plaint, Your Lordship. Defendant number 2, Harendra Basamatari, son of Sri Saniram Basamatari.
Third learner counsel, Mr. B. Bhutto, no?
B. Mukherjee. B.J. Mukherjee. B.J. Mukherjee.
B.J. Mukherjee, learner counsel for the appellant or petitioner? Learner counsel for the petitioner and Miss
P. Sir.
P. Sharma.
Yes, Lordship. Respondent number 1.
Appearing for respondent number 1. Full stop. The learner counsel for the petitioner has submitted that notices have been issued properly to the respondent whose name in the plaint is similar to the notice, and so is the name of the petitioner's father and the address of the petitioner, as well as the address of the petitioner. So it is further submitted that the petitioner is at present contesting the TS number 13 of 2022 under the same name and address.
Lordship.
He's still contesting.
Lordship.
And he is appearing regularly before the trial court. Full stop. Seen the report of the Jari Karak that the surname that the petitioner has refused to accept the notice as the surname of the petitioner and father's name of the petitioner as claimed by the petitioner is not similar. Full stop. An order has been passed by this court on 26/5/2025 to file proper application for correction of the surname of respondent number 2 and his father's name. Full stop. The service report of the petitioner service report of the Jari Karak marked as X1 is brought to the notice of this court, which correctly reflects the name of the petitioner which correctly reflects the petitioner's name and surname. Full stop. The petitioner's father's name is also similar, except for the fact that the petitioner's father has passed away. Full stop. It appears that the petitioner has deliberately refused to accept notice, and thus notice is deemed to be served. So this will come up for hearing now.
Admission.
Admission. List this matter for admission. After 2 weeks, 3 weeks. Better, I think he'll send it to Lavazima court. It will be better.
That can be done.
কিন্তু আগৰখিনি কাটি পেলাই লাৱাজিমা কোৰ্টলৈ হেৰি কৰি দিয়া ফৰ চাৰ্ভিচ অফ চামান্স বুলি লিখি দিয়া
After 1 week, then
after 1 week. No, 1 week.
Lawazima will take a call.
I think they will need 3 weeks. At least after 3 weeks we'll need them.
Item 21.
Here the real share of the petitioner is that to transfer a domestic violence case from Kachar, Richard Kachar from Siribhumi. But here the respondent had on 29/2024 had appeared, but later on she didn't appear.
So we'll list it for admission then. Hearing.
Or Lordship, may
Today
before
itself.
yes, Lordship. Last 2 occasions they failed to appear. Small matter, 1.5 year pending.
Only one date lapse. Only one date.
Today is the second date.
Today is the second date, yes. So we can give a last opportunity and then we'll pass an order. Learned
Yes.
Counsel Mr. PJ Das is present for the petitioner. who
Yes,
stopped
Dash.
the-
Yes, Dash. Yes, Dash.
S. Das. Okay. Learned Counsel Mr. Earlier it was the journalist PJ Das. Mr. S. Das is present for the petitioner, full stop. Or respondent is not represented today, full stop. A last opportunity is accorded to the respondent. Full stop on failure of any on absence of any of the parties on the next week, fixed, comma, necessary orders may be passed. This after 1 week. যোৱাবাৰ আহিছিলেতো নাই নেকি ৱালাটা নম্বৰ দিয়া কথা আছিলে নিদিলে সেইকাৰণে নাই কল লিষ্টত
Item 22.
May I please also? This case, I am appearing for respondent, my lord. The affidavit of opposition will be filed today, my lord. So, my lord, next week may be listed, my lord.
My ladyship, my senior is out of station to attend his wife's treatment. So the matter may kindly be listed after 3 weeks. Interim order passed
weeks?
earlier may kindly be
Yes, yes.
2 weeks, my lord.
continued.
Yes, tell us something about wife's ailment, I believe.
Yes, yes.
Let us give her 3 weeks. What is your name?
J. Handik.
Learned Counsel Miss J. Hendig is present on behalf of Learned Counsel Mr. I. Chaudhary.
B. Acharya.
On behalf of Learned Counsel Mr. B. Acharya, full stop, Learned Counsel Mr.
A Zahid.
A. Zahid is present. Full stop, both the parties have sought adjournment. List this matter after 3 weeks.
Pledged.
Item 24.
Yeah, please.
The respondent has filed a wakalatnama, my lords. This is after notice, this is the first hearing. first time.
Only one respondent.
Only one respondent, sole respondent, my lord.
So we'll fix it for hearing
My
then.
lord.
Already admitted.
Admitted, my lords. There is an interim order also, my lord. What is it, 9/8/2024, my lord.
Learned Counsel Mr.
And Patiri.
N. Patri is present. Patiri is present for the petitioner and Learned Counsel Miss
It's Burra.
H. Bora. You have filed Wakalatnama also.
No, Lordship, not yet. We need some time to file.
Okay. He is present for the respondent and has submitted for time to file Wakalatnama. So we cannot fix it for hearing. List
There is a
after.
wakalatnama filed on behalf of the respondent, it's showing in the cause list.
Lordship, we are newly engaged counsel.
Okay. Leave this matter after 2 weeks.
Bless.
There is an interim order.
Interim order shall remain in force till the next date of listing. 2 weeks. Okay.
Bless.
Very okay.
Item 25.
Your Honor, Your Honor, we have taken steps on the lordship has taken steps according to the court order, and from the AD card, all of the three of the respondents have received the copy.
Yes.
All the three respondents have received the copy from the AD card. We can see.
AD card.
I think it is marked as X.
Three respondents.
Yes, Your Honor.
This is section 5 of Limitation
Yes.
Act.
There is a delay of 365 days. I'm a 80-year-old ailing person. I was diagnosed with polytrauma, and I have annexed
Akbar Ali, Muhammad Ali, and Ahmed Ali.
and Ahmed Ali, yes.
It was served long time back.
Yes, Your Honor.
But there's no order here. It was served in the year 2024, but till 2025 there's no order here. (31/5, 2024) last order. Then it was served on, looks like it was served on the 6/6/2024. But last order was 26/5/2025. There it was not written that notices have been served.
It is evident in the AD card. It is not reflected in the order.
Thumb impression.
Thumb impression, yes.
Here is the problem. Oh, here we have an office note. Wait. 17/6/2025. So notice issued to respond number 1, 2, and 3 through usual process. Notice was issued 17/6. Okay. 2/9/2025. Service report of notice issued by way of usual court process on respondent number 1, 2, 3. Process server's report has received stating that the notice was received by respondent number 1 himself for the process server report. Process server. I'll check the process server's report, okay?
Yes.
We have the AD card, but I'll check the process server's report because that office notice relating to process server's report. Process server report আছে বুলি কৈছে। এইটো AD cardটোতো আগৰ তাৰপিছত order চৰ্ডাৰ হৈ গৈছে। It's awesome to me. Just wait for a moment. Beleg item sell you.
Item 26.
Please, Your Lordship. In this matter, my lord, respondent had entered appearance, my lord, and they have filed their objection also, my lord. Lordship may fix the matter for admission hearing.
Learned counsel, Mr.
H. Rahman, Lordship.
H. Rahman is present for
Petitioner.
the petitioner. The learned counsel for the respondent has filed wakalat nama. List this matter for admission
Yes,
after
that's
2 weeks.
Yes, sir. Interim order, it may
Interim order shall remain in force till the next date of listing.
Okay, Lordship.
27.
Principal Madam, in this case, we have taken steps when our extra office note dated 16/10, notice was properly served upon a respondent, full respondent.
Okay. Learned counsel, Mr.
C. Chakraborty.
C. Chakraborty is present for the petitioners. Full stop. Office note dated 16/10/2025 indicates that notices have been served to one respondent, no?
Only one.
To the respondent. List this matter after 2 weeks in the admission column.
There's in time order.
Interim order shall remain in force till the next date of listing.
What's all?
Mm. Yes.
Lordship, he has informed me that they have withdrawn the case. It's a transfer petition, Lordship. Interim order was there, but they have in the meantime withdrawn. Just now he informed me, Lordship. The case at non-worry, Lordship. We prayed for shifting it to Gauhati.
Any
matrimonial suite, respondent number 274 oblique
so do we
24.
want to proceed with this case?
Lordship.
No.
It won't be necessary,
No,
Lordship,
it
if
is necessary.
they have withdrawn it, Lordship.
Only one case.
Only one, Lordship.
Learned counsel, Mr. Your name?
M. Bhagavati.
M. Bhagavati is present for the
Petitioner.
petitioner Rijumoni Kolita and learned counsel, Mr.
AK Das, my lord, on behalf of SC Biswas.
A.K. Das is present on behalf of learned counsel, Mr. S.C. Biswas. Full stop. The learned counsel, Mr. A.K. Das has submitted that the matrimonial suit R, within bracket R number 274 of 2024 has been withdrawn by the petitioner.
Yes,
Lordship,
no, sir.
pending before the
Has been with, which was pending before the
Court of Learned
Learned Principal Judge, Family
Family Court,
Court,
Nalbari.
learned principal judge, family court, Nalbari, has been withdrawn by the respondent.
Yes, ma'am.
Lordship.
Full stop. As this, I have submitted the, I have considered the submissions at the bar that as the matrimonial suit R number 274 of 2024 has already been withdrawn from the by the petitioner. This matter has become infructuous. Full stop. Thereafter, therefore, this petition is disposed of or dismissed. Dismissed.
Lordship, it won't be, it may be closed, Lordship. Closed, Lordship.
Therefore, matter stands closed. As the matter has become, matter stands closed. Okay, close. আছে process server report আছে এটি process server report নেই এটি কি এটো report নহয় এটো deputy registrar সহি হয় This is your case, no?
Yes, sir.
You want to submit on that toleration of delay?
Yes, your lord.
There is no process servers report. You check it. Check the file and check it. There's no process servers report.
Actually,
There's only I haven't received any process servers report.
your lordship can see in the judgment also, they these respondents have filed the WS and the
Yes, it before the earlier bench then. 2-3 dates you were present before the bench and that notices were served with thumb impression long time back. And now that where is the now we have the office note of service of notice relating to process servers report.
Yes, sir.
There's no process servers report here. I cannot find. He also cannot track. You check. You give me. Show me. Then I'll see. Outer video. Hearing this ex parte will be difficult. You see, 300 days. How can I hear you ex parte?
May it please your lordship. Lordship, office note dated 11/9/25 say that registered AD card not received for the registered post, and for process server lordship flag X is there, respondent not found at given address. So lordship may give us a chance to take step on the present address, because there were 2 addresses I mentioned in my appeal memo in the CRP also, page 2. We had taken step in the Golokganj Dhuburi address. Process server could not find, and she has a present address. Okay? So we can take in the present address, and the stay was still returnable take lordship, so stay may continue.
Continue, will continue. Learned Counsel Ms. R.D. Mazumdar is present for the petitioner. Full stop. Office note dated 11/9/2025 indicates that notice issued through registered post to the sole respondent has not, service report of notice is awaited.
Yes, Lordship.
Service report of notice issued through registered post is awaited.
Then Lordship, we can await, not take new step. We can await that till next date, maybe registry can get the verification.
Whereas process server's report reveals that notice could not be served as respondent was not found in the given address.
Yes, at that, maybe on that day, maybe. Sometimes it happens.
Okay, list this matter after 2 weeks.
Yes,
Then
Lord.
thereafter you can take steps.
Yes, Lord. Hello, ma'am.
So why don't you take fresh steps? Why didn't you place this before this court then earlier? You want to,
May allow us
you,
to take a fresh
you want to
step.
submit on 380 days. How can I hear the ex parte on an old order? And 2-3 dates, this case was placed before another bench. At that time, that thumb impression notice there, it was already served and sent back. And then now they are saying the process server's report. Clarify, Google, did you need? Lawazima? You advise what to do. You advise.
Up to your lordship.
Sorry?
Up to your lordship.
After some time.
No,
Up to me.
I leave it to your lordship.
Okay.
Your lordship, I may be allowed to take a fresh step.
Fresh steps? Okay. 300 days, that is a problem. Otherwise,
Yes.
or else I can direct the registry to clarify. You think about it. You think about it and tell me. Otherwise, I'll direct the registry to clarify why this office notice as such when there is no process server's report. Why they are sending such a note? Check office okay. At 2 p.m. Anybody wants to take adjournment or something very quick? Anybody? No, you have long, your submissions.
36.
36, okay. It already clarify Yes,
I'm
you
for
want
the
to take adjournment?
I'm for the respondent number 1 and 2. 2 weeks time may be granted, Your Lordship, for filing my.
What about the?
They have
others?
appeared. Yes, for 3 he has appeared.
I'm
For respondent number 3. Not 36.
No, petitioner side.
Petitioner.
Have you taken consent from them?
No. I just want to say that I would like to take 2 weeks time for filing my affidavit in opposition.
No, you take consent. You may file affidavit in opposition, take consent. But
Okay. Blessed.
we'll wait then.
Yes, Lord.
কোন লাগে এইটো ইমান বিচাৰি নাপালে কোনে উলিয়াই নিয়ে Okay then, ding to be served then. We can take your prayer. Let us wait for 1 day. 380 days. We got the process server's report.
Okay.
Luckily. I don't know how I missed it.
When I missed it, Your Honor.
Yes. Those experts, they have showed us the report. In IA, no? IA?
Yes, sir.
Okay. Oh, yeah.
Your Honor,
We'll
the
give
limit-
last chance. Oh, what do you say? No, not required.
Actually, in the lower court also, they have, it was ex parte order against that.
Lower court
Well,
also.
yes, after filing the WS.
All right, it's okay. Learned Counsel, Mr.
TL Chaudhary.
TN
TN
Chaudhary. TN.
Yes.
Chaudhary is present for the applicant. Please stop. Notice dated 2/9/2025 indicates that notices have been served to all the respondents who stopped the process server's report is also tagged at flag X1. Who stop? It is submitted that earlier notices were also served and acknowledgement have been received back. But this was not placed on record. Full stop. It is submitted that the respondents have earlier also not received notices in connection with the original title suit number.
Special land grabbing case 3 of 2019. Your Honor, it is your Lordship, it is in page number 37, annexure D1.
Page number
37.
And this case proceeded ex parte against them.
Yes, Your Lordship. They filed the WS and after that they did not appear.
Okay. It is submitted that after filing WS, they did not appear and this case proceeded ex parte against them.
It is reflected
It was special LG case number 3 of 2019, huh? Page number 27 of the original file to CRP file to. Do you have any authority for condonation of delay?
Your Honor, actually I was I'm a 80-year-old person, illiterate, and I'm suffering from polytrauma. I have annexed a medical report in page number 6.
The petitioner in this case, the applicant stroke petitioner is Mohammed Qasim Ali, aged about 80 years, full stop. The petitioner instituted a land grabbing case being special LG case number 3 of 2019. Full stop. The petitioner is aggrieved by the judgment and order dated 7/2/2023, whereby the petitioner's in the aforementioned case, whereby the petitioner's case was dismissed.
Yes, sir.
It is submitted that there was a delay in referring the criminal revision petition against the order passed by the page 27, no?
37.
Page
37.
37. Learned additional session judge number 2 Nagaon in special land grabbing case number 3 of 2019.
Lordship, in page number 41, it is reflected that it was proceeded ex parte. Page number 41.
That's okay. As the order was passed on, as the impugned order was passed on 7/2/2023, the period of limitation expired on 8/5/2023. Full stop. The criminal revision petition was filed on 17/5/2024, and that is after an expiry of 365 days, i.e. 1 year. Okay.
Yes, sir.
To stop, it is submitted that delay was not intentional. To stop, the petitioner is 80 years old and he is an illiterate person from a remote village who was suffering financial difficulties, full stop. The petitioner was suffering from polytrauma, i.e. multiple injuries, including injury on the left scapular bone, and he underwent treatment at AG Hospital, Nagaon, and he had to take rest for a considerable period of time to recover from his injuries. Full stop. The discharge certificate is marked as Annexure X to the petition, which reflects that the petitioner was admitted in the hospital on 6/5/2023 and discharged on 9/5/2023. It is submitted that there was no malafide on the part of the petitioner. Any authority? Any judgment? I have considered the age of the petitioner. Full stop. The discharge certificate reflects that the petitioner was improving after treatment. The petitioner was diagnosed with polytrauma. The petitioner has shown sufficient grounds for delay to be condoned. The age of the petitioner cannot be ignored. It appears that justice will be met. It appears that justice will be met. For the interest of justice, the delay of 1 year is condoned to register the connected criminal revision, civil revision petition. CRP, CRP. Okay. Item number 9. Yes, yes, sir.
Second application, earlier rejected by your lordship. FIR page 7, lordship.
Page?
Page 7. Lordship. Yes, page 7.
Yes.
May I read the FIR? Lordship?
Yes, please read.
Page 11, Lordship, page 11.
Please read, yes.
Yes. Sir, I have the honor to inform you that on 17/4/25 at about 9 p.m. my son, Priyajan Daimari, 19 years, while going to a neighbor's house, Putnath song of Uttam Nath, village Uttar Raugar, PS Udalguri, along with Sri Pankiraj Daimari, son of Philip Daimari, village Bhorkasuburi, PS Udalguri, came with a bolero car and wrongfully restrained him and they beat my son Priyajan Daimari in his face and head and kicked him. in his stomach and seriously injured him. Thereafter, having sustained his injury, my son returned home and verbally told me everything. On 18/4/25, my son wanted to go to his work, but he could not and remained asleep in his bed. As injury and pain increases on 19/4/25, my son, Priyajan Dwemari, was admitted to Udalguri Hospital and CT scan and X-ray were done, and after preliminary treatment, doctor allowed him to go home. During treatment on 24/4/25, while Priyajan went, that is the day he died, Lordship. And there is the intention to kill him, Lordship. Lordship's order is also reflecting that part also. Lordship, in fact, Lordship, this petitioner, Lordship, is suffering from Lordship typhoid. I have annexed a document, medical document at page 22, Lordship.
He's not in jail.
Not in jail, Lordship. Anticipated, Lordship.
Page?
Page 22.
Okay. Okay.
And another accused, Lordship, Uttamnath, he has already been arrested by the police.
There are two prisoners here.
There are two persons, Lordship.
Pomki and
Lordship. Two persons.
Pomki Doimari. You have one petitioner only?
No, I know him, but that another accused is there.
Okay, another accused has
That
been
he was already arrested. And
anything else?
in fact, he's a 29 years, Lordship, a young boy. So his Lordship today allow him. I will cooperate to the
29,
investigation.
21.
29 years, Lordship.
29, how can he be young? 29. Yes.
Yes, my lord, earlier the matter was rejected on 10/12/2025, my lord. There, my lord, when my lord was pleased to reject the, my lord, there is the bail prayer, my lord. So, my lord, there, my lord, already, my lord, recorded, my lord, that, my lord, at that point of time also, my lord, the same, similar in today's position, my lord, after search sheet only that was filed, my lord. Page 20, para 4, my lord, of the petition, my lord. My petitioner there also might not submitted the same, that the learned additional public prosecutor has raised serious objection, stating that the petitioner did not cooperate with the investigation, which resulted search sheet showing him as an absconder. It is further submitted that the several dates were fixed for the appearance of the petitioner, and warrants have already been issued against him, but even then, the petitioner failed to appear. It appears that petitioner's submission that he will cooperate with the appears to be leaked. And my lord, in the fight, there is the lordships, my lord. There is the I have considered the submission at the bar or circumstances. I have also considered the scanned copies of the trial. So, my lord, today also this is the same position, my lord. The case is, my lord.
Allegation is serious. He's serious in nature, and evidently he did not defend. But now, lordship, at this point of time, lordship, search sheet has already been submitted. That means investigation is already over. So if today I am granted bail, I'll cooperate with the investigation agency, Lordship. I'll cooperate with the court, Lordship. We'll go to the court. Face the trial, Lordship. And everything will come out in the trial.
I'll pass an order in the evening and I'll upload it. এইটো মই আজিয়ে পাছ কৰি দিম ডিস্পোজ দেখাই দিব পাৰিম
Item 31.
As per last office note, answered notices have come back, Your Lordship, in respect of all the respondents.
So what are you planning to do now?
Your Honor, the address is fresh steps here, but the process server's report is not received. We can take fresh steps, Your Honor, but we don't have the address. It's the same address that was given in the plaint.
You'll wait for process service report?
In the meantime, we can take fresh. Or we can wait also. 1 week, 2 weeks, we can wait.
Okay, await them. Learned Counsel Miss?
Yes, Newar.
Yes?
Newar. Newar.
Newar is present on behalf of Learned Counsel Mr.
Miss
You-
M. Hazarika, my name is there in the
Oh,
cosmos.
your name is in the cause list?
Yes, sir.
Oh,
I can-
yes, yes, okay. Ms. Asna is present. Service report on respondent is awaited. List after 2 weeks.
Obliged.
Item 32.
May I please?
Hmm.
As per office note dated 27/11/25. This notice has come back, address is door locked in duty hours.
Hmm?
Address is door is locked in duty hours. Is a finding. So we will be allowed to take Dusty's there.
Learned counsel, Mr.
D Majumdar.
D. Mozumdar is present for the petitioner. Full stop note, office note dated 27/11/2025 indicates that notices could not be served during the duty hours. Full stop. Notices may be served, steps may be taken, notices, steps may be taken to issue notice to Dusty Service.
Dusty service.
List after 4 weeks.
4 weeks. Much obliged.
Item 33.
Wait, please. Emma.
Yes,
I've entered appearance for all the respondents in this case.
all the respondents.
Yes.
We'll fix it for admission.
Yes, my lord. My lord, may I make one?
You want the CD or LCR?
No, as of now, LCR won't be required. Let it be fixed
Injunction
for.
letter.
My lord, it's a stage of execution where a section 47 petition has been rejected, against which they have come up in revision petition. My lord, one more there.
Mm.
There is another case, CRP IO 438 of 2025, filed by a stranger against the same execution proceeding. That is also pending before this honorable court in regard to the same execution
We'll
proceeding.
fix it together then.
My lord, CRP IO 438 of 2025.
Learned counsel, Miss.
25.
My lord, I am appearing on behalf of Mr. S.K. Ghosh.
Your name?
R. Bharali.
R. Bharali is present on behalf of learned counsel, Mr. S.K. Ghosh, representing the petitioner, who's of learned counsel, Mr. D. Chakraborty, no?
My lord.
Chakraborty is present for all the respondents. List this matter after 2 weeks
My lord.
in the admission column along with CRP number 1.
CRP IO 438 of 2025.
CRP IO 438 of 2000.
25. My lord, a date may be given.
Date of the video from 2 weeks, sir.
On 12th March.
12th March. Highly obliged.
Item 35.
Lordship, as per the office note, Lordship, AD card has written Lordship, but the signature is not legible. It is marked as X.
AD card for one respondent.
Only single sole respondent.
Return.
Yes.
Here, AD card of signature.
It's not legible as per the office note.
There is no signature, but let's see the report. With an illegible signature. What is his name? Rajesh Jain.
Rajesh Jain, Lordship.
You want to issue notice? Fresh
Or
notice?
Lordship can lay it down about the Lawajima code, Lordship, that it can be verified.
They can verify. Sahibala.
W. Sharma.
Learned counsel, Mr. W. Sharma.
Yes.
He is present on behalf of learned counsel, Mr. Your name is in the cause list?
Yes, yes.
W. Sharma is present for the petitioners. Office note. dated 26/11/2025 reflects that notices has been returned with a signature of the with a signature for the respondent, and the signature is not signature is not legible. Full stop. Lawajima Court to verify and submit a report on service of notice to the respondent. Okay.
Lots of I have interim lots of here.
Okay. On data did you? 13th of March. It will continue on to 13th of March. Interim order shall remain in force till then.
Obliged lots.
Item 36.
Hey, please. The respondents have now been served.
May I please, your Lordship? Lordship, I'm for the respondent number 1 and 2. I require some time to file my affidavit in opposition. Lordship, 2 weeks time may be granted.
Except in that case, I'm for respondent number 3. Paying for there is an urgency in this matter. So a date may, if it's allowed, 9 or 10 March will be a sufficient.
9 to 10 March, I have some difficulty. It may be taken up, in the last week of March.
Last week of March, there is an occasion of Eid. So
After
now,
after
he wants 2 weeks, he wants in 7 days. Lordship, I leave it to your Lordship. Lord, ultimately, it's a matter of waiver. And the waiver thing is between me and the court, Malad. Even the bank also, Malad,
before 15.
Anyway, it's a complicated issue, it will require some time.
Your Lordship, my humble prayers before 15 March again.
All right. Learned Counsel Mr. A. Ganguly is present for the petitioner. Learned Counsel Mr. M. Alam is present for respondent number 3.
S.A. Bhakhtiar for another.
S.A. Bhakhtiar
Yes,
is present for respondent number 3, and Learned Counsel Mr.
S. Chanda.
S.
S.
Chanda
Chanda.
is present for respondent number
1 and 2.
1 and 2, and has prayed for time to file
Affidavit in opposition.
file objection.
Objection.
Okay. How many responses do we have?
3.
Three. Okay. List on 13 March. 13 March. 13 March.
March of months.
No, the interim order passed earlier.
Interim order shall remain in force till then.
Lovely.
Item 38.
Your Lordship, the respondents have appeared, so the matter may be listed for admission.
Admission, okay. Only one respondent?
1 and 2. I am okay for 1 and 2.
Any more respondents?
No.
No. Learned Counsel Miss
N. Bharadwaj.
N.
Bharadwaj.
Bharadwaj is present on behalf of Learned Counsel Mr.
M.U. Mahmood.
M.U. Mahmood. First of Learned Counsel Mr.
DJ Methi.
DJ Medhi
On behalf of Z Bharadwaj.
is present on behalf of Learned Counsel Mr. G. Bharadwaj, representing respondent number
1
1
and
and 2. First up, pleadings are complete and trial court records are before us. List this matter in the admission column. Admission?
Yes.
All right. After 2 weeks, list this matter in the admission column after 2 weeks.
Well, Lord, in this case, we
Yes.
file in IA for early hearing, my lord. Matter,
For early hearing, okay.
my lord, yes, my lord. Earlier, by order dated 22/10/2025, matter was fixed for hearing in the month of November 2024. But matter is not coming up in the list. But
Okay.
trial court, the date may be fixed, my lord.
We'll fix it for early hearing. Learned Counsel Mr. A.R. Sigda is present for the applicant, and Learned Counsel.
And for the, ma'am, S.N. Ahmed on the behalf of R. Chaudhary.
S.N. Ahmed is present on behalf of
Ahmed.
Learned Counsel Ms. R. Chaudhary, representing respondent number 1.
I'm for the respondent number 1, 2, 3.
1, 2, and 3.
S. Ahmed on the behalf of Miss R. Chaudhary.
Okay. Respondent number 1, 2, and 3. Full stop. This application is filed with prayer for an early hearing of CRP IO number 88 of 2025. Post office is submitted that this case by order dated 22/10/2025 was fixed for hearing in the month of November, but till date, the matter has not come up for hearing. Full stop thereby. Requested to list this matter immediately for early hearing.
My lord, date may be fixed, my lord.
On
That can be possible after 21st March.
No, no, no.
21st March. 24?
24th of March, my lord, I have some problem. I have some case fixed in outside Gauhati. 26th March.
26? Positively without fail.
Obliged.
In terms
People
of the
obliged.
above observation, I stands disposed of.
People obliged.
Okay.
Please, Lordship.
Yes, yes.
Then in this case, I am praying for deposition and release of at least 50% of the awarded amount, Lordship. Though the appeal was admitted, no amount has been directed to be deposited or released.
Okay.
Lordship, in this case, permit issue is there, Lordship. LCR has come. So,
Permit?
Lordship, after servicing the other respondent, the matter may be finally heard, Lordship.
This matter was stayed.
No, Lordship. I have
Stay is not there. They have withdrawn this.
You are so unlucky. See, nobody is asking for stay in your cases.
Yes.
Last time also there was one case.
Lordship, Lordship. As you Lordship advised last
remember.
occasion that
Hmm.
separate petition should be filed. I filed petition. So similar case, Lordship, you should, Lordship, violation permit, Lordship.
If this matter is not stayed,
Not stayed, Lordship.
we'll fix it for hearing.
Lordship, 50% may be released. Claimants are suffering, Lordship. Claimant number 3, at the time of accident was 6 years old. Lordship, he lost his father due to accident, and prior to that, 3 months back, he lost his mother.
You have deposited?
No, Lordship,
No.
I have not deposited, Lordship.
Might be directed to deposit 50% at least and release the same. If required, will furnish bond.
My humble submission, since the.
Then we will
Yes.
stay.
Huh?
Then we will stay. Even if you're not calling for stay. I won't stay.
Lordship,
No, there's no prayer for stay.
there is no point of a stay. Why I will file a stay petition?
No, that is what I'm saying. There's no prayer
They
for
have
stay.
withdrawn the stay petition.
You have withdrawn the stay petition.
Lordship,
No
Since
stay.
the lower court record has come, that is why I have withdrawn it.
Then let us fix it for hearing.
Lordship, that
Deposit. Who is the appellant here?
Lordship, violation of permit only.
No,
It
no.
will be only case for pay and recovery.
Have you deposited any amount in
No
a?
amount has been
No,
deposited.
Lordship.
Directed to deposit the
Deposited.
50% at least and to release the same.
No, we will fix it for early hearing.
Lordship, early service is not complete. Lordship, can you see the record? Appeal. He is not strongly objecting the same, Lordship.
No, Lordship.
Subject, I will find his bond.
Okay, then. Okay. Because you have preferred the appeal, no?
Yes, Lordship.
So when you have preferred the appeal, then they're not getting the money. You have not
Lordship.
deposited also the money.
Moreover, Lordship, claimant number 3, minor son,
No,
3
no.
years, 6 years old.
When this appeal,
Lordship, Lordship,
there's no stay or
No stay.
stay in this appeal.
no
I'm
stay.
telling you, when there's no stay
Lordship.
order of stay in this
Lordship,
appeal,
Lordship.
then they'll have to deposit the money because that appellate court has given some time, I think 3 months
No.
time.
They will not deposit the same.
Then they will have to
Lordship.
pay the interest.
Problem is that lower court record is here, not there. And for that we cannot file execution case.
LCR
At least 50% may be released. He is not objecting strongly.
LCR has come, Lordship. So.
Lordship, service is not complete. Lordship, kindly just see the record.
No, their money has been deposited.
Lordship,
It
Then,
will come after.
you are
if the
submitting my order here, money has been
he
deposited.
is not strongly objecting it. I will find his bond, Lordship, if we can.
Hard learned concern Mr. M. Talukdar for the applicant. who has prayed for, who has made a prayer that to direct the, where is the prayer?
Well,
I to give, huh?
Lordship, can be in the post title itself.
Direct the appellant stroke opposite party, comma, the New India Insurance to deposit 50% of the compensation awarded by the learned member MACT Kachar at Silchar in connection with MSc case number 367 of 2022, whereby the learned tribunal has directed the insurance company had order dated 3/5/2022, 25 to award to pay a compensation of rupees. What is the amount?
Amount is 21 lakhs 46,400.
21 lakhs 46,400
400.
with interest at the rate of how much?
9%.
9%.
9% from the date of filing of petition or
Claim petition.
from date of filing of claim petition. First up, the learned counsel for the insurance company stroke respondent has raised objection stating that the permit, that the route permit has been disputed by the route permit, no? Route permit, huh?
Was not valid.
Route permit has been disputed by the insurance company and has claimed that the route permit was not valid at the time of the accident. Full stop. The appellant stroke respondent has preferred this appeal, and as the trial court records are before this court, comma, the claimant is suffering immensely because the appellant has not deposited the compensation. Full stop. It is submitted that the appellant respondent, who is the respondent here?
Here in this case,
In this case, in IA, I am for the opposite party.
opposite parties. Number 1.
No, here not respondent, here the
Opposite
claimant, who is the claimant here?
Claim applicant. Applicants 1 to 8.
Here the claimants 1 to 8 are the widow and the
Number 1 and 2, parents of the deceased. 3, minor son, and others are brothers and sisters. Minor.
1 and 2 applicants number 1 and 2 are the parents of the deceased, and
3 is minor son. At the time of accident, he was 6 years old.
3 is the minor son of the deceased.
And he lost his mother.
Whereas the other respondents are being brothers of the deceased are
Minor
dependents.
brothers.
Were dependents on the deceased. Were dependents of the deceased. Brothers and siblings, the brothers, siblings of the deceased were dependents of the deceased. Because of the wife of the deceased predeceasing.
Is the
died in the
applicant
same
number
accident.
3.
Huh?
Applicant number 3 is the minor son of the
wife
deceased.
Deceased died in the same accident.
Prior to that, 3 months back.
The wife of the deceased has passed away. Full stop. Considering the plight of the claimants, comma, and as the appeal is before, appeal is, and as the appeal is pending for hearing. Oh, and
No,
as the
not hearing,
pending,
Lordship.
appeal is pending here,
Lordship.
appeal is pending and has not been fixed for hearing. Full stop. Notices are yet to be issued to the respondents,
Yes, one number 9 and 10.
which will
9 and 10.
further
not so-
delay in the hearing of the appeal. Full stop. It appears that an order may be passed directing the insurance company to deposit 50% of the compensation awarded to the claimants. Because of thereby, the insurance company is directed to deposit 50% of the compensation awarded to the claimant within 6 weeks from the date of this order, and the claimant number 1 and 2.
One, maybe.
Claimant number 1 may withdraw the amount on after executing an indemnity bond and after proper before the registry of this court,
Yes.
6 weeks from today before the registry of this
Registry.
court, indemnity, and after proper verification by the continuing registry, the claimant number 1 may withdraw the
Claimant applicant number 1.
claimant
Claimant
number 1.
applicant number 1.
The claimant number 1 may withdraw the 50% of the compensation. Okay. In terms of the above observation, this IS stands disposed of. A make appeal to Lichidia.
Appeal is, there is or effective order last.
Appeal is admitted only, long time.
Appeal, there is order, await service reports on 9 and 10.
The service report on respond number 9 and 10 is awaited.
Like this.
List after 4 weeks. Appeal to Lichidia.
Obliged.
Lichidia,
Obliged.